From delays for judgment item 1, first appeal 75 of 2023.
This appeal filed by dependent number 6 and 7 is allowed to the India Social Comes.
From the court number 16, one matter in the 2001 to withdraw this writ application. And for this consent.
Who is for the other side? On. बुला के लेके आइए.
Your initial one matter which was listed at supplementary list.
Please watch notes. From the list of court number 16 notes were mentioned before watching notes. And for yesterday, for listing it today.
Election.
Yes, notes. It has been listed, but not again. Court note is not available.
Come at 3 o'clock.
3 o'clock notes. Taking consent, I will inform the other side.
All the others.
Item number notes 3 of court number 16.
Supplementary.
Supplementary list.
Because I think this matter which was mentioned by learned advocate general, I file an IA, so IA may be also called for.
आइए ना सर.
IA number? Just
लिख के दीजिए.
6374.
मंगा लीजिए आइए मंगा.
किस सीरियल?
आगे
सीरियल केस नंबर.
अभी मेंशन किया.
अच्छा वही वाला.
फाइलिंग नंबर
ठीक.
IA number 6374 of 2025.
There's two matters in fact from court number 16 that it was fixed because my bank account has been frozen. It's a trade union dispute. The bank, without there being an order, just because it's a bank's union, the Bank of India has said there's a dispute, we are freezing the account. There is no provision in law where the employer can exercise its right as an employer, and that's what they've done. The entire functioning is crippled. It's to their advantage.
You are for the bank? Come at 3 o'clock. ऐसे कैसे करते हैं आप? आपका पैसा है, घर का है. बैंक कुछ नहीं करेगा. There can be a garnishee order, right? There can be an adjudication. ऐसे आपको मन होगा कि ये आपका पैसा है, उनका पैसा है, ऐसे नहीं. ट्रेड यूनियन का डिस्प्यूट है तो वो लोग अपना रिजॉल्व करेंगे.
हाँ वो भी है. One is connected with that, but the registrar has not passed any order of freezing the bank account. They have misinterpreted. I don't know which registrar's order have brought on record. Your should see.
May I mention from the supplementary calls to the list of court number 16 matter. 4 matters tied together under heading low I have taken the consent of others.
You are there?
Yes, sir.
Should it be sent for local service? You are the sole respondent?
Yes, sir.
और तो कोई नहीं है?
No, no, it is only
Private party?
No, ma'am. There is no private party. Private party. For the JUBA.
देखिए तो ये कौन सा केस नंबर?
Serial WPC 1774/2020.
आइटम 4 का बैच केस.
4 to 7.
4 to 7. With the consent of the learned counsels for the parties, let this matter be placed before the ensuing
Direction may be given that the competent officer will remain present.
Direction
Because
हम लोग अदालत में
payment has to be made.
भाई आपका जो है लोक अदालत में कंसेंट से जा रहा है तो यू मेक अरेंजमेंट.
With your latest and permission, serial number 18 from the legal legislation. It kindly will be taken out leadership because writ of the legal opposition has been issued by the learned
सीरियल नंबर
18 1A.
किस हेडिंग में?
Delhi legislation. For order 41 rule 11. Second appeal number 242 of 2023.
Sorry, serial number 18.
Yes, sir.
This is arising out of what kind of dispute?
This is dispute between legal heirs of the same mother, and partition suit was there.
ये जो मेंशन मैटर्स है उसके बाद आप
from supplementary list for final disclosure item 1, first appeal 181 of 2023.
So in this case, I have got the wakalat number from the side of the appellant from which the notice has been sent to me. I pray for time in this case for any day after that.
क्या बात है भाई, जिसको वकालतनामा है वो एप्लीकेट नहीं होता है और नया काउंसिल आके टाइम मांगता है, मतलब क्यों नहीं हम इसको डिसमिस फॉर डिफॉल्ट कर देते?
अपीयर नहीं हो रहा था इसलिए नोटिस किया गया
हाँ, इसीलिए नोटिस किया, तो आपको और सावधानी से वकालतनामा फाइल करना चाहिए ना, क्यों नहीं किया वकालतनामा? बहुत बड़ा एहसान किया, वकालतनामा मिल गया।
अब फाइल मिला है, थोड़ा सा इसमें एक्कोमोडेशन चाहिए।
सर्व तो आपको बहुत दिन हो गए, आपके लिटिगेंट को सर्व में बहुत दिन हो गए। चलिए क्या करेंगे बताइए, कब रखें? रेस्पोंडेंट भी एब्सेंट है।
आफ्टर वैकेशन किसी दिन रख दिया।
मिस्टर पूरा नाम बताएं।
अरशद हुसैन।
अरशद हुसैन, एडवोकेट, undertakes to file wakalatnama on behalf of the appellants during the course of the case. Let the wakalatnama be. Nobody appears on behalf of the respondents. Record article. At the request of the appellant, pose this case under the same heading on. बताइए कौन सा दिन? कैलेंडर में देखने में इतना टाइम लगता है? आप बता दीजिए ना, अगला दिन में आप ही टाइम मांगेंगे, इसलिए पूछ रहे हैं आपसे। बताइए कौन सा दिन आपको पसंद है?
11th को
11th को 11 दिन।
For admission item 3, content schedule 438 of 2025.
Because there is one part of the order which has to be combined. So I'll take Manas to page 14 of my petition.
Why are you not going to them?
Manas, this is the first time when they have asked me to come. So Manas, now I am now in receipt of that letter. Manas, I take into consideration that this petition is 80 years old now. So now he is in Delhi for some of the checkup, some regular checkup. He was in Delhi. So what I am insisting, Manas, any day after the court reopens, any date may fix, he will manage and he will go.
So manager ऐसे थोड़ी होता है। आपको बुलाएंगे, आप नहीं जाएंगे, जब बुलाएंगे तो बोलेंगे 80 years old है। जब रिट फाइल किए थे तो होश नहीं था कि 80 years old है।
No, but then I can ask so something which
When
was not paid
will
to
you go? Tell me the date.
anything our MLS first week of June, any date.
आप अपने मन से मत बोलिए।
No, I have taken instruction. That's right. I have taken instruction. I was very
Date
clear.
and time. Date and time. 80 साल के व्यक्ति के लिए कुछ रिस्पेक्ट देते हुए उन्हीं के हिसाब से डेट एंड टाइम फिक्स कर दें। बताइए।
So 12th of June, that's a Thursday, Manas.
At 11 AM. Correct?
Yes.
किसके पास जाएंगे ओपी नंबर?
जो डिपोनेंट है
AGM HR works.
No, he is general manager SPCELD. He is the person concerned against whom they have filed this. And he is the general manager, he can mark.
You OP number 1 also?
OP number 1, they have made Pradeep Kumar Gupta as a party. I have said on affidavit there is no Pradeep Kumar Gupta, his name is Pawan Kumar.
So he was then changed over there. So I'll go to Pawan Kumar Gupta.
I have said
Yeah, designation by the direction that would be
Designation is
Deputy General Manager.
General Manager.
General
he is general manager SPCELD.
ठीक। Okay, content civil 438 of 2025. Counsel for the parties are present. The learned counsel for the opposite party has submitted that the competent authority to give hearing to the petitioner is General Manager within bracket SPC dash capital E bracket close in sales/BSL, who is posted at Bokaro, and the present incumbent is one Mr. Pawan Kumar.
But I have to say there was no Pradeep Kumar Gupta at any point of time.
अरे यहाँ पे है ना Pawan Kumar.
हाँ अभी वही है.
At present is Pawan Kumar Gupta. He has also submitted that the opposite party number one, namely Pradeep Kumar Gupta, was never the deputy general manager or the employee of the Bokaro of sales/BSL. He submits that repeated letters have been issued for hearing, but the petitioner has not. The learned counsel for the petitioner has submitted that he has taken instructions from his client, who is around 80 years of age, and therefore he could not appear on account of certain medical condition. However, he shall appear before the aforesaid incumbent on 12th of June at 11 a.m. At this, counsel for the opposite party has submitted that if he appears on that day, appropriate hearing will be done and ordered. Considering the appropriate submissions, let this matter be adjourned and posted on 8th of August.
Yes.
The supplementary show cause along with the reasoned order and the supplementary show cause, the compliance report, correct? Be filed by 4th of August.
Yes.
As per the undertaking of the petitioner and the counsel for the opposite party, the petition shall appear on 12th of June at 11 a.m. and he will be heard in connection.
In-person hearing will be given.
From taking list for orders verified item 2, first appeal 167 of 2024.
Yes. Who is appearing? That is the defect.
Item 2 from daily list. नाम फिर
डिफेक्टिव है आपका petition.
हम देख लो.
इसमें 3 लोगों का वकालतनामा नहीं है. अपील नंबर 678, बाकी आप देख लीजिए. देखिए एफए नंबर 167 of 2024. The learned counsel for the appellant prays for and is granted time till 20th of June 2025 to remove the surviving defect. Print. If the defects are removed within time, post on 26th of June. And the application. दिखा दीजिए फाइल देख लीजिए मिस्टर राहुल. फाइल देखिए.
For admission item 6, first appeal 80 of 2025.
क्या मैटर है?
ये पार्टीशन सूट जो है सो डिक्री हुआ था, हम लोग डिफेंडेंट हैं, उसी के अगेंस्ट
एडमिशन के लिए आए हैं.
एडमिशन.
FA number 80 of 2025. Counsel for the appellant is present. Admitted. Issue notice to the respondents.
Respondents, private respondents is
To the respondent number 2 to 5. State को सर्व किया आपने?
हाँ स्टेट को सर्विस को.
आप सबको सर्व करेंगे. Respondent number, all the respondents, ठीक है, for which requisites under ordinary process be filed by 10th of June the appellant shall also file a registered cover so that the notices to be served upon the respondents is dispatched to the concerned court for service. नहीं तो मेरी दिक्कत हो रही है, पहुँचता नहीं है यहाँ से सर्विस रिपोर्ट। जितना पहले ऑर्डिनरी नोटिस बनाएंगे,
हाँ।
उसको एनवेलप में डालकर
हाँ।
बे करा के उसमें रजिस्ट्री का वो डाल देंगे और जमा करेंगे। तो वो लोग पूरा रजिस्ट्री से भेज देंगे सिविल कोर्ट को और उसके बाद वहाँ से सर्विस। Post this case on 10th of July, awaiting service. Let this order be communicated twice.
Item 7, first appeal 81 of 2025.
Admission के लिए है।
Yes.
Nobody appears on behalf of the appellant. Admit. Issue notice to the respondents under ordinary process or both same type of. Office is directed to call for records from the concerned court. Let this order be communicated through fax. Same date with the requisites can be same date or the same date. Let a soft copy of this order be communicated to the council for the appellant for 5 days.
For hearing under order 41 to 11. Item 8, second appeal 366 of 2019.
Appeal is by the plaintiff against the concurrent findings. The suit was filed seeking for the relief for cancellation. Cancellation of sale deed executed by the appellant in favor of the defendants. On the ground that the deed was got executed by way of undue influence. Courts below found that we have not been
What was the undue influence?
According to us, our case was that first of all we sold 6 decimals of land. Then
Undue influence क्या है?
undue influence, that I have explained for that purpose. That what the case which we tried to set up. First we executed a sale deed for 6 decimals. Then we were having further land adjoining to the said land. Then we agreed to sell 1 decimal C. And then we could realize thereafter that they are trying to amalgamate the purchased land with our other remaining land. We sold them 6 by 1 sale deed, then 1, and then in that event we found that they are making effort to amalgamate this purchased land along with our remaining royalty land. So then on that cause of action, we sought for the relief, seeking for cancellation of the sale deeds.
Is it a ground for cancellation?
To be on the legal side is concerned, I would submit that the courts below have in fact not committed an error. I could not show any. In fact, I could not show any substantial error by the courts below.
Fair enough. These
And-
are absolutely scrutiny of evidence.
Yes. Because later on we tried to develop that it was the consideration was not paid, but that is
That is not the ground.
No, that was beyond.
That was not the claim also.
Yes, I would only submit that our case is concerned. That can only be quoted from what we have tried to argue before the learned courts below.
Where will I get?
Yes, I will just refer to the relevant page 18, that is internal page 7 of the title suit judgment. Just I refer to the running page 44. Running page 44. That would be internal page 17 of the judgment of the learned first court. There 5, para 5.4. And the learning courts will have dealt with the provisions of the Contract Act, section 16, and then come to a finding that we have not been able to adduce such evidence.
How is the council paying to behalf of the appellant? This appeal has been filed by the plaintiffs against concurrent findings recorded by both the courts. The trial court had dismissed the suit by judgment dated 29/11/2017 and decree dated 8/12/2017, passed in title suit number 36 of 2007 by learned civil judge within Kentucky Junior Division, that is Cooperative. And the learned appellate court has affirmed the judgment by judgment dated 6th of August 2019, within that decree dated 9/8/2019, that was in civil appeal number 1 of 2018, passed by learned District and Additional Sessions Judge Roman Kokar. The learned counsel for the appellant has submitted that the plaintiff had filed a suit seeking cancellation of sale deed executed by the appellant in favor of the defendant. He has submitted that a ground of undue influence was taken for the cancellation of sale deed. The learned counsel has submitted that initially 6 decimal of land was sold by a registered sale deed to the defendant, and further adjoining land of 1 decimal was also sold.
Yes.
However, the defendant was trying to encroach upon the remaining realty land of the appellant, and therefore the suit was filed for cancellation of the earlier sale deed. Upon perusal of the improved judgments, this court finds that the plaintiffs claim to be rightful owner of Schedule A property purchased by them by registered deed dated 13/12/68 and another portion by registered deed dated 17/3/1988. It was their case that since they were in urgent need of money, they desired to dispose of a portion of the Schedule A land, and defendant agreed to purchase the same, which was mentioned in Schedule B property of the plaint, and it was sold by registered deed dated 13/5/2000. It was further case of the plaintiff that during the execution of the sale deed, the plaintiff measured the Schedule B property and prepared a plan by recognized a mean in presence of the defendant, and the area of 6 decimal has been measured from north to south 37 feet 2 inches, from east to west on the northern side 78 feet, and east to west on the southern side 63 feet, and the said plan is a part and parcel and was attached to the sale deed dated 13/5/2002. The defendant started construction over the property and covered the same and obtained the possession of 6 decimal of land of the Schedule B plaint. It is further case of the plaintiff that the defendant expressed his desire to purchase another portion of the suit land adjacent to Schedule B property to the extent of 1 acre, and the plaintiff again measured the same in presence of the defendant and executed a sale deed by registered sale deed dated 3/7/2006. During the execution of the sale deed, both the parties again prepared the plan by recognized a mean of an area of 0.1 decimal and duly measured from north to south 5 feet 1 inch, east to west 7 feet, details of which was mentioned in Schedule B by one of the plaintiffs. It was further case that during subsequent measurement of the land 0.1 decimal, it was transpired that the defendant had violated and measured the measurement of Schedule B land to the extent of an area of 0.6 decimal and grabbed the major portion of the land from the northern side of the Schedule B land and demolished the wall of the northern side of Schedule B land with an intention to grab more land with Schedule B land. There was also a joint measurement with a mean, and the difference between the parties was resolved in the month of June 2007, whereby the defendant agreed to acquire 7 decimal of land of the opposite 2 sale deeds. But later on, the plaintiffs came to know that the defendant is intending to extend northern boundary of the Schedule B property, to which the plaintiff raised objection, and due to this, the plaintiffs became very apprehensive, and ultimately the suit was filed seeking cancellation of registered sale deed dated 15/7/2007. The registered sale deed number 2482 dated 13/5/2023. सिर्फ एक ही cancellation मांगे हैं.
हाँ एक दो अलग अलग सूट था वो एक अलग है.
The suit was filed seeking cancellation of the FHA sale deed, and the learned counsel for the appellant has submitted that for the other sale deed, another suit was filed. The defendants contested the suit. The learned trial court framed the following issues for consideration. All the issues were decided.
Yes, all findings has been given.
All the issues were decided in favor against the plaintiff and in favor of the defendant.
Except the formal issues with regard to maintainability.
Except the formal issues with regard to maintainability, etc. Before the learned appellate court, the main issues were taken from paragraph 5 onwards. The learned appellate court also considered the materials on record
Formulated 1 point for
and
determination.
formulated 1 point for determination. Where is that?
Para 8, running page 19.
Running page
19.
1.
19. Internal 8. It is in Hindi.
Just a minute. At para 8. As to whether the registered दोनों सेल डीड
उसमें उनका पॉइंट डिटरमिनेशन के लिए किए थे, बट हम लोग रिलीफ एक ही कमा रहे हैं.
as to whether the registered sale deed involved in the case could be set aside on the ground that the defendant was trying to encroach upon the properties. The first appellate court has considered the materials on record and has dismissed the appeal and has relied upon the judgment passed by the Honorable Supreme Court in the case of Prem Singh and others versus Birbal, reported in bracket 2006, bracket 5 SCC 353, wherein it has been observed that a registered document is prima facie valid, and when a document is valid, no question can arise for consideration. The learned first appellate court also observed that no ground for cancellation of the sale deed was made out by the appellant and ultimately dismissed the appeal. After going through the interim judgments, this court finds that both learned courts have considered the materials on record and have found that no ground for cancellation of sale deed was made out. Admittedly, there was no such ground regarding fraud or non-payment of consideration. There has been no substantial question of law involved in this case. Accordingly, this appeal is hereby dismissed. किस केस में?
Just last
क्या करना है?
week. Only my presence will be there.
ऐसे नहीं होता. आपका केस एडमिट करते हैं. डिसमिस थोड़ी किया है, एडमिट कर. Yes. So the point.
Item 9, second appeal 3.08.2019.
Yes, appellant. Are you appealing for the response?
Yes.
Notices were issued to you.
Caveat.
You are
Yeah,
on
the caveat.
caveat.
We are the original plaintiffs and the caveator.
अभी आपका क्या काम है? सेकेंड अपनी में सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं बना है.
And if so far as if a caveator is there, then caveator has a right of hearing on so far the admission is concerned on the issue of substance. That is.
कौन सा लॉ पढ़ा रहे हैं?
That is that on that there is a judgment also.
No, there is no.
There is a judgment also because.
You see, I don't mind hearing you, but you do not have a right.
No, that is if I am not a caveator. That is if I am not a caveator, I do not have a right of hearing. If I am not a caveator, but if I am a caveator, then I have
If
a
you
right.
are a caveator, then you will have a right of hearing so far as interim relief is concerned. But so far as the admission of the case on framing substantial question of law is concerned, you have nothing to say.
On that it is up to the honorable court. But so far as on that there are judgments, particularly judgments pronounced.
Judgments लेके आना.
नहीं अभी हम तो कर रहे हैं. अगर इनका होगा तो होगा. हम लोग एडमिशन के बाद ऑब्जेक्शन करेंगे.
इसीलिए आप दूर ही रहिए ना. फिर क्यों परेशान हैं? I will record that I have not heard the caveator for the purposes of framing
नहीं
substantial.
अगर उस पर 148A का लैंग्वेज
एक बार अगर आपको सुन के कर लिए तो मॉडिफाई नहीं करेंगे substantial question. Your right for modification or that this question of law does not arise, ये सब खत्म हो
नहीं
गया.
वो तो नेचुरल है. अगर हम मेरे सामने हो गया तो फिर हम प्रेयर कर भी नहीं सकते हैं.
अच्छा बताइए, इसमें बहस करने का कोई मुद्दा ही नहीं.
पूरा स्कोप ही है,
आप
पूरा
क्या
स्कोप ही
सुन
है.
रहे हैं?
तुरंत एडमिट कर दीजिए, खाली 2 मिनट खाली हम बहस करेंगे.
इतना फास्ट
हाँ,
मेरे
बिल्कुल
दिमाग नहीं
बिल्कुल.
चलता है.
हम तो लॉ पॉइंट पर ही बहस करेंगे. दिस इज डिपेंडेंट सेकंड अपील अगेंस्ट द जजमेंट ऑफ एफर्मेंस. द प्लेंटिफ फाइल टाइटल सूट फॉर इजेक्टमेंट ऑफ डिफेंडेंट फ्रॉम द सूट प्रॉपर्टी एंड ग्रांट परमानेंट इंजंक्शन लॉर्डशिप. But the learned trial court and appellate court has decided the title lordship, which is against the order 7 rule 7. No relief was claimed. May kindly see plaintiff lordship. I have brought the copy of the plaintiff lordship. May kindly see relief claimed by the plaintiff lordship.
डिग्री में नहीं है क्या?
क्या चीज?
क्या रिलीफ आप क्लेम किए थे?
नहीं, हम तो प्लेंट की ही कॉपी लाए हैं ना, और हम जजमेंट से भी दिखा दे रहे हैं.
अरे डिग्री नहीं, आप ट्रायल कोर्ट का डिग्री नहीं निकालते हैं.
नहीं लगाते हैं मुझे.
दिखाइए ना, उसी में पोस्ट में गलत लिख देगा क्या?
नहीं, जजमेंट टाइटल डिसाइड कर दिए लर्नेड ट्रायल कोर्ट.
अरे भाई, क्या आप रिलीफ पे किए हैं तो डिग्री में लिखा होता है कि
डिग्री
नहीं?
में बिल्कुल
हाँ,
बिल्कुल
तो
लिखा होता है.
बताइए, डिग्री से दिखाइए.
डिग्री का तो कॉपी मेरे लगता है मेरे पास नहीं है. डिग्री कॉपी नहीं है. हम जैसे प्लेट को कॉपी लाए ही थे.
ये क्या लैंडलॉर्ड टेनेंट है क्या है?
नहीं, हम लोग कहते हैं कि परचेज किए हैं. प्लेंटिफ केस से रघुनंदन डे एंड कालाचंद डे परचेज द लैंड and therefore a agreement was executed on 4/9/1995, but the sale deed was not executed. The Raghunandan Day lordship filed a specific performance of contract, suit was decreed, therefore agreement was executed. Sale deed was executed by the process of the court lordship. तो हम लोग का केस है कि executant of the agreement has not right title to sell the land lordship. This is the case.
जब तक आपका टाइटल नहीं डिक्लेयर होगा तब तक ये रिलीफ आपको कैसे मिलेगा?
नहीं, हम तो डिफेंडेंट है ना, हम प्लेंटिफ नहीं है.
अच्छा,
हम डिफेंडेंट है कि नो रिलीफ वाज क्लेम फॉर डिक्लेरेशन ऑफ राइट टाइटल इंटरेस्ट. द क्लेम ऑफ द प्लेंटिफ ओनली eviction of the defendant lordship, but London trial court has decided the title which is against the order 7 rule 7 lordship.
नहीं ऐसा नहीं है. अगर मान लीजिए किसी का टाइटल ही नहीं होगा तो उसको क्या राइट होगा?
So how the London trial court lordship decreed the suit on the basis if there is no relief claim by the plaintiff lordship, there is a direct judgment lordship regarding. I will produce before this honorable court lordship.
हाँ. Did you join issues on the point of title or not?
Lordship?
Did you join issues on the point of title?
No.
Issue frame हुआ था?
देख लेते बता.
issue number 6.
But there is no relief lordship.
Just a moment. If both the parties are claiming title,
I am not claiming. The plaintiff claiming. I am the defendant.
you are, but you also claimed title. Didn't you claim title?
Lordship.
Did you claim title in
No,
the written statement?
Why should I claim the title? Because
Did you or did you not? Did you claim your title with respect to the sold property in the written statement? Plaintiff did not claim any declaration of title, because the plaintiff did not have any cloud over the title. He was well convinced that I have title over the property. He wanted only eviction. But once you raise an objection regarding title, that issue will be framed and decided.
But there is a decision on Rule Supreme Court 2014.
देखिए ऐसा इतना मतलब AI से मैं नहीं चलती हूँ, इतना मेरा दिमाग काम नहीं करता है कि आपके मेमोरी से आप जजमेंट बताएंगे और बस हमको क्लिक करने लगेगा, इतना लॉ हमको नहीं आता।
देख लेते हैं वो क्लेम की
क्या आप जजमेंट नहीं लेके आते खाली 2014 2013 में देखा तो यहाँ पर आपको सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम करने में बताइए। Not ready?
नहीं, हम तो टाइटल में नहीं देखे थे, हम तो सिर्फ रिलीज पर ही किए थे।
वही तो बात है, not ready. पढ़िए पास ओवर।
Item K, second appeal 199 of 2022.
Yes, Akila. बताइए।
Last occasion you Lordship used to call for LCR regarding the additional evidence.
कौन सा ऑर्डर?
18 for
आ गया है। आया है? देखे हैं? कहाँ है बताइए? कौन सा एडिशनल एविडेंस दिखाई?
during the pendency of the case before the appellate court, Your Lordship, the one RMA case has been decided in my favor, Your Lordship, in which TL case, I have filed a revision case against TL case, Your Lordship, which has been adduced by the plaintiff, Your Lordship, as evidence, Your Lordship, in trial court, Your Lordship.
Okay.
During the pendency of the appellate court, Your Lordship, the matter is pending before the appellate court. The TL case has been decided in my favor, Your Lordship. The RMA number 56 of 2009 and 10.
Where is the additional evidence? Appellate court में additional evidence?
Yes.
आइए फाइल किए होंगे।
Your Lordship, you should be a
हाँ बताइए कहाँ? आप देखे नहीं? खोज के हम नहीं निकालेंगे ना?
Your Lordship, record for him that.
बताइए कहाँ है? आपके एडिशनल एविडेंस को कंसीडर नहीं किया? एडिशनल एविडेंस दिखाइए आप, बस इतना ही तो है। एडिशनल एविडेंस की कहानी ऑर्डर शीट में होगी, है ना?
इसी का है।
ऑर्डर शीट देखें हैं? The court pronounced the judgment at 3 p.m. और 4:10 में आपने एप्लीकेशन फाइल किया फॉर एडिशनल एविडेंस।
अटेंडेंस भी शुरू में ही पड़ जाता, शुरू में ही दे दिया था।
ये सब कहानी हमको मत सुनाएं, ठीक है? ये ऑर्डर शीट में गलत लिखा है, तो लिखे हैं ऑर्डर शीट ऑफ द ट्रायल कोर्ट और द ऑर्डर शीट ऑफ द एपेलेट कोर्ट, जजमेंट के बाद एडिशनल एविडेंस क्या करेंगे?
सुबह में ही अटेंडेंस भी पड़ जाता है, ये ट्रेडिशनल जिस तरह से है।
ऐसा ट्रेडिशन हम नहीं जानते क्योंकि हम वहाँ प्रैक्टिस नहीं किए, हमको इस बात का कोई आइडिया नहीं।
उसमें जो प्लेंटिव उसमें डिफेंडेंट जो है लॉर्डशिप, उनका अटेंडेंस भी है लॉर्डशिप, जिन्होंने फाइल किया। ये ऑर्डर है लॉर्डशिप,
और इसमें रिसीविंग भी है 4:05। अब एडिशनल एविडेंस के ऊपर रिसीविंग लिखा हुआ
मेरे में ऐसा कोई रिसीविंग
दिखाइए
रिकॉर्ड पर है लॉर्डशिप।
रिकॉर्ड पे तो बहुत चीज रहता है, जजमेंट प्रोनाउंस होने के बाद फाइल की। अब इसका उपाय सुनिए, क्या करें आप? ये तो नहीं हो सकता है।
Lordship, before pronouncing the judgment, your lordship, clearly case has been decided, your lordship, and on the date of the
देखिए वो मिस्टर विशाल कुमार तिवारी वहाँ बैठे, वो आपको उपाय बताएंगे। इसको अटेंड करते हैं, उपाय बताइए। चलिए, किसी से पूछने में कुछ बुराई नहीं है, वो मुस्कुरा रहे हैं, उनको पता है इसका उपाय। आपका फेवर का बात करेंगे, छुट्टी के बाद रख दे रहे हैं, समझ के आइए, कुछ फाइल करना है तो करके आइए। एक ऑर्डर है जो ट्रायल कोर्ट में प्रोड्यूस हुआ है, वो ऑर्डर सेटिसाइड हो गया है, जो आपने एडिशनल एविडेंस के साथ फाइल किया है एपेलेट कोर्ट में। एपेलेट कोर्ट जजमेंट प्रोनाउंस करने के बाद लिख रहा है कि वो आपने फाइल किया, तो भी इसका उपाय है, वो मिस्टर तिवारी से पूछिए। हम यहाँ पे आपके एडवाइजर भी बैठे। एट द रिक्वेस्ट ऑफ द काउंसिल फॉर द अपीलेंट पोस्ट दिस केस ऑन 12 जून। बताइए भाई इनको। चलिए,
Special case from court number 16 for production is for press filing act number 1 WPC 1933 of 2025 along with act number 2.
1 and 2 में भी
1933 is the matter under which the include order is at page 56.
1933.
Page 56.
Why 2 cases?
Two cases, one is against the order of registrar and one is against the order of the bank. So both were heard in order to be distributed. Page 56. Subject regarding the
Notice has
dispute.
already been issued in this case.
No, they have appeared, but the bank was served.
Is it fresh filing?
It's fresh. Page 56 here also is the order.
And there's
They also received to the Bank of India officers subject regarding the dispute over operations of accounts. So the reference to the caption subject, it is stated that due to the ongoing dispute regarding this election of General Secretary and the order of Additional Registrar Labour Department Ranchi dated 21/2/2025, the above mentioned account number has been debit frozen. That the account will remain debit frozen until we receive an order from the court of competent jurisdiction in this regard or a letter of settlement from the parties, that is from Sunil Lakra and Prakash Rao. As it has come to our attention that Sunil Lakra has approached the Labour Department and it has been observed by the Additional Registrar in the order that while electing the new General Secretary, provisions of Constitution has not been followed. But there is no order of freezing by any of us.
Well, the instruction is required. Well, there is a reference of order dated 21st of February 2025 by the Registrar Labour Department.
Abhi आप stay कर रहे
But it will amount
Take your
to,
instruction.
and it will amount to granting of final relief.
No, will not amount. Stay of frozen. No, give me some on the face of it.
Well, there is reference of order, one order dated.
I have made a capital statement that there is no such order. There is an order which is under challenge by is of 24/2/2025, that is at page 55. I have annexed the order, page 55 of the registrar, but that does not talk about staying or the freezing of the bank account.
This order is of 24th February. The reference is of 21st
So
February.
I have said there is no order of 21st February. If you make a wrong noting, then what can I do?
रजिस्ट्रार को पार्टी बनाए
हाँ रजिस्ट्रार कहेंगे, दूसरे केस में पार्टी.
इसमें रजिस्ट्रार कहाँ
Labor Department, Registrar Labor Department is not.
No, they are a connected matter because the registrar is responsible for 4 and 5. In this case also 4 and 5, state government.
4 and 5 रजिस्ट्रार ट्रेड यूनियन
Yes. Well, that is the trade union only, not
Who is
labor.
appealing? Produce this order.
Yes.
अभी मंगाइए इसको. Produce this order.
नहीं 24 फरवरी का तो ये खुद लगाया
24 फरवरी का लगा है 21 फरवरी का.
बस पता लगा कोई 21st February
अब
का
बता
order है.
दीजिए 21 फरवरी का ऑर्डर है कि नहीं है द मैटर है.
बस because हमारे हिसाब से 21st
अभी
या 24th तक.
अभी आ रहे हैं. Get that order please. 4:30 बजे तक भी ले आएंगे तो हो जाएगा.
पता कर लेते हैं पता
पता कर लीजिए.
जब मिनिस्टर साहब का स्टेटमेंट है कि ये 24 फरवरी का ही है ठीक है.
Item 3 WPC 2485 of 2025.
What's the state of Jharkhand before your lordship knows?
See, these records do not go to me, so you explain.
Yes, notes. Note, take notes a couple of minutes. Bear with me. I'm not come notes step by step. Matter relates to DISCOMA. Some notes multi-state cooperative society having its operations not in Bihar and Jharkhand both. Operating note from before the national state of Jharkhand. That is not in the erstwhile state of Bihar. It had its operation, and by virtue of the 1984 Act, multi-state cooperative society and the new amendment of 2002, new Act 2002, it is a multi-state cooperative society. In view of the fact that it has operation both in Bihar and Jharkhand. But for that note, there was also a certificate issued in 2014 by the Central Registrar of the Cooperative Societies by declaring it to be a multi-state cooperative society with an area of operation in the state of Bihar and Jharkhand.
Wait, that's it.
That is what page 24. First paragraph notes, last line. The area of operation of the society shall be confined to the state of Bihar and Jharkhand. The bylaws of the society shall, insofar as they are not inconsistent, shall continue, and thereafter it is ordered also. Now, what similar? First paragraph, last line. Similar issue arose about with respect to the division of assets note of Bihar notes Milk Federation Cooperative Society. This was answered by your lordship note here in division bench, confirmed to the Supreme Court. Notes that assets and liabilities have to be distributed, and it is the central government alone note under section 41 and 42 of the Bihar Nation Act. There was an order passed by the state of Jharkhand in that note matter. This was challenged by the Bihar Federation Cooperative Society. Jharkhand said that we also have societies of the affiliate societies in Jharkhand, milk societies, and they declared the assets in Jharkhand to be its own assets, which was challenged by the Bihar society. Jharkhand government, the division bench could answer it. Supreme Court said that the Jharkhand government's order is correct, and the matter was referred under 41.2 for the to division of assets. Here also, note, division of assets was not complete; it is still pending. No asset division has happened. Now, I'm going to kindly see.
When it has already been declared to be a multi-state cooperative society, then it will remain as a multi-state.
It will remain as a multi.
So how? Where is the
Even
question
if
of
it is-
division of assets and liabilities?
Those assets not which are in Jharkhand. So it is not 100% not, almost 99% of the assets not was created by the Bihar government, which was also in Bihar. So after the creation of successor state of Bihar and Jharkhand, the assets has to be divided between Jharkhand and Bihar.
I'm unable to understand when the cooperative society is a multi-state.
Yes, I know that is different issue. I am saying that assets is falling in the state of Jharkhand. Liabilities both has to be not portioned. Between Bihar and Jharkhand, it will remain as a multi-state cooperative society, but not our stakes has to be determined.
So for a state of Bihar and state of
State of
Jharkhand,
Jharkhand is not
what
concerned.
proportion it would
What
be there?
proportion and what will be my rights and liabilities, and what will be the rights and liabilities of the state of Bihar. To that extent, it is not that point it has ended; it continues. Like not the milk federation. Now not kindly see the one provision notes which I am saying. Kindly see this page 46. Board of Directors. Now all the lands node and packs node cooperative societies node are the members of the cooperative society, including the state of Bihar and Jharkhand. Page 46 note, section got the rule squad 27 of the bylaws of this Viscoman. Amended bylaws. Management of Viscomans are based in a board of directors consisting of 21 members, as below. Thoughts have noted it? It says that 15 shall be elected from the delegates representing a class member, of which a minimum of one each shall be woman, SC and SC OBC candidate. 2 shall be elected from the delegates representing B class member. Then notes 5 and 6, Roman 5 and Roman 6. 1 shall be the registrar cooperative society Bihar as his nominee. 1 shall be the registrar cooperative society Jharkhand or his nominee. Now this bylaws note has not been amended. This is amended bylaws note which was not registered note. Kindly see at page 25, Lecture 2. Page note 26, 25. It starts from page 26, 2nd February 24. The bylaws amended note. These are the bylaws. It still survives note where in the bylaws itself, note the state of Jharkhand has a nominee director, notes, one nominee. Thereafter, notes what has happened is the elections notes were proposed for the board of directors. Kindly come to note initial 3 at page 65. For the office bearers of the board of directors, an election is to be conducted not out of the persons who have been elected. But I read clause 27 of the bylaws, 15, 2, and not then nominees. Now this note
amongst the elected members, there is a further
office bearers.
Office bearers.
Not among the elected members will become directors, and then among the directors, the office bearers will be president and secretary and all those notes. So we nominated notes. Kindly see 6th February 25, page 65.
And that is
Jharkhand government notes nominated under clause 27(6) a friend George Kuzur, deputy registrar cooperative societies, as its nominee. Then notes come to page 66. Page 66, Lecture 4. I am directed to refer to your letter number so and so. This is not by the Government of India, not by the Central Registrar Office. Not.
yes, can you read it?
Yes, ma'am. He is writing to the returning officer and district magistrate Patna, Viscoma. I am directed to refer to your letter number so and so of 20th February regarding the nominations of Government of Bihar, Jharkhand, and NCDC on the board of Viscoma, and to say that matter has been considered by the Cooperative Election Authority and decided as a so there is no provision of Cooperative Election Authority under section 45I of the Lord's Multi-State Cooperatives Act.
25I.
45. Central Registrar nominates, central government nominates one of the authorities to conduct and supervise the elections of the multi-state cooperative societies. It is seen that section 48(1)(a) of the Multi-State Cooperative Societies Act 2002 envisages nomination of one member on the board of a multi-state cooperative society in cases where the equity share capital held by the central and state government is less than 26%. the Jharkhand government's one nomination of registrar of cooperative societies within the clause 48(1)(a), government is considering that our share is not up to 26% or less than 26%. If it is more than 26%, it will be 2 nominees. And if it is more than 51%, 3 nominees. That is what section 45.
So where is the
48, section 48. Problem, I mean, this is not, now the cause of action is developing, but just not, we just go through this later. It is seen that section 48, one of this so and so, and this are nominated in cases with the equity says so and so. The Jharkhand government's one nomination registrar shows within this clause 48, government of Jharkhand has equity share value of approximately rupees 14.60 lakhs. But we are claiming more than this, but nevertheless not we accept, because assets and liabilities are still to be not decided. As indicated in notification of 31/1/2025 of the Government of Bihar. Government of Bihar itself not is saying that we have not this much of share approximately, and on that basis our share was decided to be less than 26, and therefore one nominee was accepted. This is the letter. Now note what happens. Kindly see NSR 5. They publish the list. Note what has happened. Note in this matter is they are postponing the election several times. Not up to the stage where not only they will be left to be not winning. Otherwise, they are excluding everybody who can object. NSR 5 page 67. The list of members, directors have been notified. Kindly see our nominee's name is there. Nominee Sadas last name. The Prem George Kujur which was given by us by the state of Jharkhand.
Last name, yes, please.
Prem George Kujur. Nidesak Sahayog Samiti Jharkhand Ranchi. And this is the notification of the district magistrate Patna. In terms of the order passed by the central cooperative registrar. Then now what happens? They reschedule the elections. It has been rescheduled twice, successively, lords. On 21st, that is what page 68. They fixed the election for 28 February. Then they reschedule it. And it's a 6. Revised election program. Instead of 28th February, they reschedule it for 8th March.
Then?
And you see in this page, this is also very crucial, page 69. Here also the number of directors, nominees names, Government of Jharkhand also is mentioned.
Bihar and Jharkhand Bihar Corporation. Page 69.
Page 69, the third row. Number of directors 21, related group A, B, C 17, and 3 from Government of Bihar, 1 from Government of Jharkhand. Is there? Now what happened after that? Government of Bihar page 17. Just to exclude us from the entire process, Dinam page 17 got intercepted. Dinam 31st January 2025 द्वारा यह स्पष्ट किया गया कि बिहार राज्य क्रय विक्रय संघ के कुल चुकता हिस्सा पूंजी में से बिहार का निवेशित हिस्सा पूंजी 99.26% है. Is not what they are confusing is Bihar. Bihar is the erstwhile Bihar, not the successor state of Bihar. Since Bihar, there was no Jharkhand at that time. इस क्रम में यह स्पष्ट करना है कि यह संपूर्ण हिस्सा पूंजी बिहार सरकार द्वारा प्रदत्त एवं धारित है तथा शेष 0.7% हिस्सा पूंजी सदस्य सहकारी समितियों का है. The other affiliated cooperative societies in Bihar and Jharkhand, we have also 80 cooperative societies that are affiliated to this command out of 270. Jharkhand
so they have taken the entire asset to themselves.
Successor Bihar considers itself to be the erstwhile state of Bihar. So therefore, there is no Jharkhand as of now, even today, as according to them. Then they write.
So you are taken as 0 on the 15th of November 2000.
Yes.
You stand at 0.
Yes.
On 15th of November
15th
2000. And
and
whatever assets you contribute, it will come only thereafter. And the entire thing goes to the state of
everything
Bihar.
goes to Bihar. Where have we have contributed? I am coming to that. I just not concluded. Then they say that our nomination is not in accordance with 48(1)(c). I will not refer to 48.
Nomination was initially accepted.
It was initially an order of the Central Cooperative
Yes.
Registrar, yes, and it was upon their letter, 31st January
And
25.
this is a unilateral action.
It is unilateral action. I'm coming
Once
to that.
the election commences, these kind of letters.
They are trying to change not the voters list. That is what I'm trying to emphasize. Voters list for the office. I'm still not kindly see. Let me not conclude. Thereafter, after this letter of 3rd April, now the central registrar takes a U-turn and passes this order. And it's a rate at place 20, which is the impugn order, not here. Now this is the what he is writing to the returning officer, district manager, Patna. Now note is not very relevant, but I will just not go through it. It's a 2-page order. I am directed to refer to return number so and so of 3rd May on the above cited subject and to say that by the letter of event number of so and so 22nd April, CEA, that is not Central Electoral Election Authority, had requested RO Biskuman to seek comments on the Registrar of Society Jharkhand by giving clear 7 days time period on the Government of Bihar's notification number 3rd April 25. That is not have seen the previous page, 3rd April 25. He is writing that I wrote to the Biskuman RO to seek comments of the Government of Jharkhand on your letter of 3rd April, stating that Government of Jharkhand has no shareholding in Biskuman. Now kindly see next. Comments of the RO were called to determine inclusion, exclusion of the representatives nominee director under section 48(1)(a) of MSCS Act and under Rule 19A or so and so for nomination of RCS Government of Jharkhand on the board of Biskuman, along with participation to cast vote in the election of office. The notification of 3rd April states as follows. Notice has been quoted. The last ballots have seen that. This entire letter has been quoted. RO had a letter of 3rd May has stated that comments of RGS Government of Jharkhand have not been received till date and has also agreed with the notification of Government of Bihar dated 3rd April 25 regarding nil shareholding of Jharkhand Government in Biskuman. Now, not did unilaterally say that my shareholding has been reduced from 14 lakhs to 0, nil, and no comments have been received from Government of Jharkhand. Now, I do not receive this any letter from the RO of Bihar. Now, the intervener props up today and says that a letter was written on 22nd April, the same day when this letter is being written, this particular letter. Then we have not received that letter. Anyway, it is in their notes file, maybe not dispatched. In view of the comments, recommendations of the RO Biskuman, inter alia, mentioning about absence of response from RCS Government of Jharkhand and agreeing with notification of 3rd April 25 of Government of Bihar, the Cooperative Election Authority considered the matter in its second meeting held on 5th May. And in view of the above provisions of 48(1)(a) are not applicable as far as Government of Jharkhand is concerned. Earlier, authority has taken note of RCS Government of Jharkhand's letter of 8th February addressed to Administrator Biskuman seeking a seat on the Board of Directors as per bylaws on 27/6. Keeping in view position as in preceding paragraph, the Cooperative Election Authority decided that there cannot be a nominee director of Government of Jharkhand on the Board of Biskuman in the absence of equity shareholding. Now he decides my equity shareholding also. Therefore, the number of directors who would participate and vote in enclosed election program for election of public bearers in Biskuman on 8th and 9th May will be 20 directors only, that is 17 elected members, 3 nominated Government of Bihar. My in-laws.
The election is today also.
Tomorrow.
8th of
Today,
May?
nomination. Election is tomorrow. 8th and 9th May will be 20 directors only. The issues will be approval of. Now, can you see election 9 lots? This was written in 2000 by Lord Bihar, saying that my percentage, my assets notes proportion is 37%, and I have given my note share. Page 76 note. My liability has been fixed to be of 37% here. शेष राशि के भुगतान के मामले में note this regards to loan given by Biskuman, which also note comes into my liability, and it says शेष राशि के भुगतान के मामले में the first line I am reading notes. माननीय मुख्यमंत्री के निर्देशानुसार चूंकि राज्य का विभाजन हो चुका है, अतः 62.27% का भुगतान बिहार सरकार तथा 37.73% का भुगतान झारखंड सरकार को करना है।
लाइबिलिटी के लिए आप
हमारा आर्टिकल हम है बिहार को हमको कुछ मतलब हमको कुछ देंगे नहीं, लेकिन लेने के लिए हर चीज हमारे लिए तैयार है। And after 270 cooperatives, and he decides my liability. It is only the central government which will decide the liabilities of the lots interstate between the Bihar and Jharkhand.
But there is already some shareholding mentioned.
In their letter, Bihar's letter, lots. Government of Bihar's letter.
Yes.
And they unilaterally decided for one. First they decide I have a ratio.
क्या बोलना है? Will you take the state of Jharkhand to 0 on the date of creation? ये 99.8% कहाँ से आया?
नहीं, वो तो इनिशियली जब कोऑपरेटिव सोसाइटी बना था उस समय का स्टेटस है वो।
जब
तो
cooperative
स्टेट
society
गवर्नमेंट
बना
का
होगा,
नहीं, स्टेट गवर्नमेंट का शेयर जो था उस समय जब बिस्कुमान बना था उस समय उसका शेयर जो डिफाइन किया हुआ था वो मेंशन किया हुआ है, वो अभी भी कंटिन्यू चल रहा है। नाउ द क्वेश्चन इज विद रिस्पेक्ट टू ऑल द एसेट्स एंड
नहीं, पर पहले हमारे दिमाग में समझ नहीं आ रहा कि जब ये बिस्कुमान बांध बना होगा तो उस वक्त तो स्टेट ऑफ झारखंड नहीं होगा।
नहीं, हम तो दूसरी चीज बोल रहे हैं कि जो अभी फेयर का बात हो रहा है, एसेट्स एंड लायबिलिटीज का बात हो रहा है, क्वेश्चन इज विद रिस्पेक्ट टू द मल्टी स्टेट कोऑपरेटिव सोसाइटी एक्ट एप्लीकेशन इन द प्रेजेंट केस इन द this situation itself. You will also take into consideration that before issuance of this order at Annexure 1, registration under the Multi-State Cooperative Society Act. Lord, can we see for a moment Annexure 1? Page 23 to 24. In pursuance to the order passed by the High Court of Patna in Writ Petition number so and so, Board of Director of Viscoman versus Government of India dated 2nd July 2014, a society by the name of Bihar State Cooperative Marketing Union Limited Viscoman Bhavan so and so has been registered as a multi-state cooperative society under section 103 of the Multi-State Cooperative Society Act and the rules framed thereunder. The registration number of the society is so and so. The area of operation of the society shall be confined to the state of Bihar and Jharkhand. Well, this is the registration which was made in the year 2014. Well, so far as the Act is concerned, if your lordship will take into consideration, the Act Multi-State Cooperative Society Act is concerned. I'll take your lordship Act. Melody, it says with respect to section 5.
Yes.
Multi-state cooperative society which may be registered. No multi-state cooperative society shall be registered under this act unless its main objects are to serve the interest
Section
of members.
103.
Section 5.
103 is this. 103 also there.
Section 5 बताइए.
Multi-state cooperative society which may be registered. First, no multi-state cooperative society shall be registered under this act unless its main objects are to serve the interest of members in more than one state. Well, this was the first condition so far as the registration under this act is concerned, which has been done in pursuance to the order passed by the Honorable Patna High Court in 2014. So far as the area of operation of this society has been fixed to be state of Bihar and state of Jharkhand. Thereafter, Lordship, can you see so far as the process is concerned, the section 7 is there, 8 registration certificate. Then Lordship, can you see section 9?
Yes.
The registration of a multi-state cooperative society shall render it a body corporate by the name under which it is registered, having perpetual succession and a common seal, and with power to acquire, hold and dispose of property, both movable and immovable property, enter into contract, institute and defend suits and other legal proceedings, and to do all things necessary for the purpose for which it is constituted, and shall by the said name sue or be sued. My lord, here itself your lordship will take into consideration that this is a cooperative society shall render it a body corporate itself. Well, therefore, the existence of this society is like a body corporate. Therefore, so far as the role of state government is concerned, my lord, with respect to the liability or assets that is there itself, Lord, that is not to be taken into consideration for this aspect, my lord, so far as the existence of the society is concerned. Now, your lordship, can we come to bylaws? My lord, section 10, subsection 2, my lord. The bylaws are concerned in particular and without prejudice to the generality of the foregoing power. Such bylaws may provide for all or any of the following matters, namely the name, address and area of operation of the society. This is state of Bihar and state of Jharkhand, which has been incorporated, which my learned friend has shown. Now your lordship kindly come to section 84, my lord now. This is chapter 9, my lord, settlement of dispute, reference of dispute. Notwithstanding anything containing any other law for the time being in force, if any dispute other than a dispute regarding disciplinary action taken by a multi-state cooperative society against its paid employees or an industrial dispute as defined in clause K of section 2 of the Industrial Dispute Act touching the constitution, management or business of a multi-state cooperative society arises among members, past members, persons claiming through members, past members and deceased members, or between a member, past member, persons claiming through member, past member or deceased member and the multi-state cooperative society, its board or any officer, agent or employee of the multi-state cooperative society or liquidator past or present, or between the multi-state cooperative society or its board and any past board, any officer, agent or employee or any past officer, past agent or past employee, heirs or legal representative of the any deceased officer, deceased agent or deceased employee of the multi-state cooperative society, or between the multi-state cooperative society and any other multi-state cooperative society, between multi-state cooperative society and liquidator, etc. So and so, such dispute shall be referred to arbitration.
This dispute, the nature of dispute that he is raising is not covered by any of
Well, I'll come to what you can do. For the purpose of subsection 1, the following shall be deemed to be dispute touching the constitution, management or business of a multi-state cooperative society, namely, clause C, any dispute arising in connection with the election of any officer of a multi-state cooperative society.
This is not an election dispute because election has not yet taken place.
Well, that is
Yes,
See,
I am not even
in connection with, the word used in connection with, Lord. It is not only with respect to the election, but this is my submission, Lord. So far as in connection word which is being said in connection with the election, that includes, Lord, the prior preparation to the election and subsequent to the election
They
itself.
are not even considering me a member.
Well, therefore, it is a part with respect to which, Lord, whether he is being nominated or accepted as a member, he will be a member with respect to the participating in the election. Otherwise, the matter is not very urgent. On that ground, it has been said, Lord, that the urgency has been shown to be there itself, that election
then under
is.
such circumstances, the election is required to be deferred.
Well, Lord, I am saying submitting, Lord.
No, because it's a very serious dispute.
Well, Lord, therefore,
you are
I am coming.
totally outstanding a particular.
Well, Lord, the question is with respect to the assets and liability. Lord, so kindly see section 48, Lord. Now kindly see section 48 under which, Lord, the power with respect to that part, Lord, the nominee is concerned. Lord, so kindly see the power which has been conferred under the Act. Lord, the bylaws, Lord, cannot supersede so far as the Act is concerned. Lord, section 48 has
bylaws are also approved by you, isn't it?
approved, Lord, that is there itself, Lord, but
So
the provision
that
is,
has the force of law.
yes, it has a force of law. I am not saying, but if at all it is in, so far as the requirement under section 48 of the Act is concerned, that is first to be seen, whether it is there or not. Well, kindly see section 48, where the central government or the state government has subscribed to the share capital of a multi-state cooperative society. Multi-state cooperative society, the central government or the state government, as the case may be, or any person authorized by the central government or the state government shall have right to nominate on the board such number of persons as its member on the following basis, namely, where the total amount of issued equity share capital held by the central government or the state government is less than 26% of the total issued equity share capital, one member of the board. Where the total amount of issued equity share capital held by the central government or the state government is 26% or more, but less than 51% of the total issued equity share capital to members of the board, where the total amount of issued equity share capital held by the central government or the state government is 51% or more of the total issued share capital, 3 members of the
Just
board.
pause here for a moment. You see, it is the maximum prescribed for one nomination is 26%.
Yes, my lord. My lord, I am coming
They
to
are
that.
fighting
My lord.
only
I'll
for one
explain, my lord.
nomination.
I'll explain
My
your
question
lordship
is
query,
not
my
yet
lord.
over.
That is the question, my lord, which is to be determined, and it has
Just-
not been
just-
yet determined, my lord.
just-
Because kindly see 103, my lord.
एक
now.
बार मेरी बात because for one nomination, even if you have 0.001%, if it is not zero, right? If you have 0.001%, then also you have a nomination in the board. One member.
The question is with respect to the determination of assets and liability between state of Bihar and the state of Jharkhand.
As per your understanding, does the state of Jharkhand has any equity share capital or
That
it is
the-
zero?
Therefore, can we come to 103, my lord?
The time.
Cooperative societies functioning immediately before reorganization of states, where by virtue of provision of Part 2 of the State Reorganization Act or any other enactment relating to reorganization of states, any cooperative society which immediately before the day on which the reorganization takes place had its objects confined to one state becomes, as from that day, a multi-state cooperative society. It shall be deemed to be a multi-state cooperative society registered under a corresponding provision of this Act, and the bylaws of such society shall, insofar as they are not inconsistent with the provision of this Act, continue to be in force until altered or rescinded. Close to, my lord. If it appears to the central registrar or any other officer authorized in this behalf by the central government, herein after this section referred to as authorized officer, that it is necessary or expedient to reconstitute or reorganize any society referred to in subsection 1, the central registrar or the authorized officer, or as the case may be with the previous approval of the central government, places before a meeting of the general body of that society, held in such manner as may be prescribed, a scheme for the reconstitution or reorganization, including proposals regarding the formation of new multi-state cooperative society and the transfer thereto in the whole or in part of the assets and liabilities of that society. Malab, so far as subsection 203 is concerned, Malab, that has not been done till date. Malab, since 2014, Malab, this society has come into existence, Malab, after registration under this act itself. But so far as this part is concerned, it has not been decided till date. Therefore, at the moment, Malab, the existing thing which was there itself, so far as the state of Bihar share is concerned, 99.2% or 6% is concerned, Malab, that was there. On the basis thereof, Malab, so far as the election which was to be done, that has been proceeded with, Malab. Because in terms of section 48, unless this 103(2) is being decided, so far as this part is concerned, Malab, the subsequently on the issue.
Unless this 103 is being decided in terms of subsection 2, then the state of Jharkhand has to be put at zero. Why not state of Bihar should be put at zero?
My lord, so far as the state of Bihar is concerned, this society is there itself, my lord. It is not as such.
Merely because the new
That is
state
the
of
effect of reorganization, my lord. That is the effect of reorganization act itself.
After the reorganization, there are two new states. One is the new state of Bihar and another is
Therefore, my
a
lord,
new state of
therefore, my
Jharkhand.
lord, for
So
last
you
year-
cannot equate the present state of
I am not
Bihar.
equating, my lord, so far as that
Then
part
why
is
have
concerned.
you
This is
taken-
the effect, my lord. This is the effect which is existing there in so far as the documents and the everything is concerned, that Bihar is there itself. The name of Bihar is there. Now that is to be determined, and in terms of determination
You need
thereafter, so
subsection
far as the
to
share capital can be determined.
So
And
unless
on presumption, my lord, it cannot be
it is not a
said.
matter of presumption. It is not a matter of presumption because the one nomination is from 1% to 46%. Correct? One nomination, 26%. One person to be nominated. If he has if anybody has a share stake to the extent of even 1%, one nomination is there. You can't deny that. Do you want to say that by any stretch of imagination, the state of Jharkhand at any point of time will be put at zero? And merely because the
that
essence,
presumption, my lord, cannot be
presuming.
determined at this stage, my lord. That is the finding which is to
Then
be
under
given in
such
terms of
circumstances-
103, my lord.
Then under such circumstances, under what basis have you taken the state of Jharkhand as zero? Merely because there
My
could
lord,
have there could
kindly
have
see
been.
if you know, my lord. Kindly see Annex 8, my lord.
Mr. Anil Kumar, please listen to me. There could have been a situation
My lord,
that
they were supposed to give a
Please-
reply to the authority,
please
my lord.
hold on.
They have
Please-
not filed any reply.
Please hold on, just a minute. There could have been a situation that this portion of the erstwhile state of Bihar could have been named as Bihar, and a new name could have come to the new state of Bihar. Merely because they are carrying that name, that will not give them an extra.
That is not the thing, my
That
lord.
is what you have done.
Since 2014, you are in 25, my lord. They have not proceeded so far as that part is
From
concerned.
2014 onwards, there has been no election.
My lord, so far as that part is concerned, they will I have not taken any
You must be knowing about it. 2014 till 2025, there has been no election. How is it possible? It just can't be. You just can't.
Page 73, my lord, can you see for a moment of the red petition? And if you not a paragraph. No reply has been received, my lord, so far as that part is concerned.
Page number?
Page 73, my lord. Of the
When was your query issued to them and by which letter? What was the letter by which it was issued to them? Tell us. लेटर का डेट बताइए. क्वेरी आपने मांगा था ना उनसे.
That is one, just a minute.
Is it there in the first page of annexure, page number 72?
22, 4, This one of 22.
You say
4,
that by letter of even number dated 22/4/2024.
CA has requested R.O. Biskumar to seek comments of the registrar of society.
Yes, this is a communication to
Biskumar.
Biskumar,
That's it.
right? This is
Biskumar.
22/4/2024. Biskumar की तरफ से कौन है?
Biskumar has written a letter number on 22/4/25.
अब भेजा किसको? Biskumar was supposed to send it.
No, to Ranchi. The
कौन सा letter?
registrar cooperative society.
Returning officer, your main party, I think district by state. Is the returning officer.
No, I am not saying that. Page number 72.
72 पे जो लिखा है
Right? ये 3/5/2024 on
वो
their
जो लेटर का
website.
रेफरेंस है 22/4/25 का.
ये 22/4/24 क्या है? 22/4/25 नहीं है, 22/4/24.
नहीं, 22/4/25 का लेटर है जो इलेक्शन ऑफिसर बिस्कुमान लिखे पटना, ये रजिस्ट्रार कोऑपरेटिव सोसाइटी रांची को.
कब लिखे? 22/4.
22/4/25.
इलेक्शन ऑफिसर लिखे. ऑर्डर तो आप पास कर. And it was received by them when? 22/4 को
That is
ठीक है.
not with me. That is not with me.
इंटरनल है सब सेंट्रल गवर्नमेंट से आरो जिसको मान डिस्ट्रिक्ट मैजिस्ट्रेट को बोला गया यू सीक कमेंट्स फ्रॉम झारखंड 22/4. On the same day note, it appears that note they are showing by the intervener showing that the letter was given. It was not dispatched, no dispatch is shown there. We have not received that letter. No comments from us. But better is still note, my rights are to be decided. It cannot be decided on the basis of a single letter of note comment of behalf.
अगर comments नहीं भी आया, then also you will take a unilateral decision. There are two things. One is that you are seeking comments, right? You are now you are taken a decision. Now you want to take another decision, right? You are seeking comments. Then after seeking comments, also they have a right of hearing also. How
The
this
date of
unilateral
election was
decision?
announced in the meantime.
आप announce
That
करते
has been
रहिए.
deferred.
इतना भी क्या हड़बड़ी है आपको? अभी तक तो आप बोलते कोई इलेक्शन ही नहीं किया आज तक.
नहीं, ये हम नहीं बोल रहे, हम तो बोल रहे हैं हमको नहीं पता है.
आप देखिए आपके लिटिगेंट को पता होगा.
नहीं, उनको पता होगा, हम नहीं बात की है इस विषय में, हम तो यही बात
May I
है.
say something?
Yes, please.
We have not been made party. We have moved an
Whom are you
application for
representing?
intervention. Same matter, same.
Whom are you representing?
The elected members, Millers.
Okay.
Now, Millers, there is a preliminary submission before going into the details, and the question was very pertinent that even if it is 1%, he is to be allowed. But that has been taken care of, Millers, in the impugned letter which is under challenge, that it is 0%. That is at page 73. My Lord's specific query was there. Less than 26, Millers, that is the section 48. Then nomination is permissible. But if my Lords may see para 3, my Lords got it? संख्या नंबर 7, बिहार का निवेशित हिस्सा पूंजी 99.26% है. इस क्रम में यह स्पष्ट करना है कि यह संपूर्ण हिस्सा पूंजी बिहार सरकार द्वारा प्रदत्त एवं धारित तथा शेष 0.74% हिस्सा पूंजी सदस्य सहकारी समितियों की है. झारखंड सरकार की कोई हिस्सा पूंजी नहीं है और ये 48(1)(c) के अनुकूल नहीं है. That is because my Lords raised that query that even if it is less than 1%, 0.1%, still then he can be nominated. But there is a larger issue, my Lord. My Lords may take the Constitution, Article 131. Because the two prayers and the dispute is between the central government and the state government. And both the prayers are against the central government and the state government. Then the only original jurisdiction is that of the Supreme Court, to the exclusion of all the high courts. May I read it?
Yes.
I'm sorry. Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, which includes the High Court also, have original jurisdiction in any dispute between the Government of India or more than one state, between the Government of India and any state or states, between two or more states. If and so far as the dispute involves any question, whether on law or on facts, on which the existence or extent of a legal right depends, provided that the said jurisdiction, this is the only exception, if there is any agreement or covenant or treaty prior to the enactment of the Constitution. And my Lords may see the prayer now. And there is a constitution-like judgment also on this because this Article 131 is more than clear. If my Lords may see the first prayer, for issuance of a writ of certiorari to quash and cancel the letter dated 5/5/2025 issued by respondent number 3, that is the central government. My Lords got it?
Yes.
The memo parties is at page.
That's right. That has been issued by central government.
Yes, friends. No dispute on that, because page 2 of the memo party. The second prayer is against the state of Bihar for issuance of a writ of certiorari to quash and cancel the notification issued by the respondent number 2 contained in memo number so and so and 3/4/2025. The rest are So my humble prayer will be that it will be open for them to invoke the original jurisdiction of the Supreme Court, since the dispute pertains between two states and the center, and the only jurisdiction to the exclusion of any other court will be this. And it I am covered by many judgments. I need not trouble below. If my lords wants, then I should assist.
No, that's okay.
Further,
The dispute
then I
is,
can.
just a moment, according to you, the dispute is essentially between the two states, so far as the stakes in, no, center may be a neutral body.
Center, because that is how they have been ruled out. The first prayer is against the central government. That is what I am saying. The first prayer is, because straight away, if my lords may see, 5/5/2025, issued by respondent number 3, whereas it has been decided that there cannot be a nominee.
No, what I think is that there is a dispute between government of Jharkhand and government of Bihar as to their stake in Biscoman, and pursuant thereto, there is a letter issued by the central government saying that state of Jharkhand would have no equity.
Correct, because the decision-making authority is the central government. That is why they have challenged only that letter. And the state of Bihar is the second following that letter. And nomination, I am informed below that. And since I was not even made party, I am seeking liberty to assist the court. But kindly see, the nomination is complete. There are judgments to that effect, Milos. My lords may issue notice and we will assist them in the matter and let it be subject to. Why I say this, Milos, then in any case, this court will have no writ jurisdiction in a matter pertaining to dispute between two states and the central government, and it is to the exclusion whether on law or on facts, both. Because what is impugned, because in the writ petition is the letter and the order of the central government followed by the state government, not Biscoman or anything else. Because the decision-making authority is both the central government as well as the state. And as regards satisfying the conscience that if it's less than 26%, even if it is 0.1, then one nomination, that also has been taken care of under 48(1)(c), that it is 0. On merit, just keeping it aside. So my lords may consider that. I am grateful my lords have given me indulgence because I am not even a party. But I was instructed to assess the court below. I am thankful.
Keep this issue open because as of now there is no objection, and then we have to yet decide as to whether in an election dispute like this.
It has come up today itself, Milos. I don't have the full paper.
But then tomorrow is the election, so what is to be done?
Yeah, today nomination has been completed. Tomorrow is the election.
Yes, Mr. Rajiv Ranjan, what do you have to say to this preliminary objection regarding the dispute between state and state of Jharkhand and state of Bihar? Will it be covered by the original jurisdiction of the Honorable Supreme Court?
It is not. It will be covered under Article 226 note. In the very same note, the first order notes as my lord could see, Annexure 1. It is arising out of an order of the Patna High Court. In that judgment itself, note the Patna High Court says the writ can be filed in Delhi High Court, Patna High Court, as well as in Jharkhand High Court. This is also with regard to whether it is a multi-state cooperative society or not, whether the rights of the party, and there was a clear direction. That being one. Here is not a dispute between the central government and the state government, or not the state government and the state government. It is vis-a-vis Lord's Act, Multi-State Cooperative Societies Act. Central government is not exercising Lord's sovereign power not to decide interstate between the state and Jharkhand, Bihar and Jharkhand. Even that is permissible under Bihar Reorganization Act under section 41 and 42. But here, it is acting as some central electoral officer authority under section 45I of the Central Cooperatives Act. And you see that not the provision.
There is one more angle to it, that whether this dispute would be essentially between two states, in the sense that both the states are having their stakes in a cooperative society, and therefore the dispute is essentially amongst the participants or the members of the cooperative society or the persons who have stakes in the cooperative society.
It is only not vis-a-vis the persons who have stakes in the multi-state cooperative society.
That's it.
Yes.
So
It is
state
not
of
covered in Article
Jharkhand,
131.
state of Jharkhand and state of Bihar, they have stakes in the
They
cooperative
are the
society
stakeholders.
and therefore they are not acting as a state in the sense of Article
State in that
131.
sense. They are members of the Notes Cooperative Society having
But this
stakeholders.
issue has to be,
It is
since
not
that
decided,
has
that is not issue raised by them, it will be decided by the Lordship. Not, there are Comfed judgment, Milk Federation Cooperative judgment of Tribunal Division Bench of Power High Court. Their interstate note dispute note of the state and Bihar and Jharkhand has been decided here. Note in under Article 226, Housing Board notes, Housing Board matter in Patna notes. All these matters note, they are the state of Bihar and Jharkhand both are the stakeholders. As to Supreme Court has affirmed all these judgments notes. Even the state of central government is empowered under section 41 to decide in case of apportionment.
just you tell us, what,
Yeah, the
what do you
election.
want from us today?
But we don't have not anything to do with nomination. It is an election tomorrow, either not we are allowed to participate in election, the result will be subject to the decision of the case, or the not elections may be stayed. These are the two options not available not for the normal court.
See, we can let the election go, firstly. Secondly, it will be subject to the result.
Subject to the permitting me to not participate in the election as a nominee, and then what's the result would be otherwise if the elections are held, then what's the purpose not is served because not I have been excluded from the election. They have all not within between February and not April, they have already not twice not they have not revised the election schedule. It was first to be held on 28th February, then it was again to be held not in March. They have revised it themselves. So election not is not very great thing for them. And both the two elections, earlier elections, I was not a nominee director.
You have participated in earlier elections.
They postponed it not because they wanted me to exclude, no, they wanted not exclusion, not my exclusion. So they revised not the election schedule.
Where is that reference to dispute?
That is section 84. That is with respect to election. Here not I have been excluded as a member itself. Not. It is only amongst the members or not vis-a-vis the election, not amongst the members. I am not a member as yet. They exclude me as a member, saying that you are zero.
Any dispute arising in connection with election of an officer of a multi-state cooperative society.
Here they say that they are not joint operation, it is a multi-state cooperative, but not, it is entirely, everything not goes and based in the state of Bihar. Jharkhand has no role to play. So I am not a member, I am not a stakeholder at this stage.
Will your dispute be covered by C?
No. That is with respect to election.
Post-election.
Post-election. Once elections are held, then any member can raise a dispute. That is what note, section note 84 says. It starts with. It starts with that. Among the members, inter se among the members.
So I have filed on IAR.
And he is not appearing for one of the nominee directors of the state of Bihar as an intervener.
Your senior is representing you, I suppose.
No.
No, I was informed, Milos. I had started with that. I am seeking liberty to intervene in the matter. And that is why I said I am here to assist the court because the matter was listed to me, so I was instructed to appear.
There is no intervention application from your
No,
side.
Milos, I could not have moved it because they have moved it only today. Where is the question of my moving?
We can't
But
take
in a question.
notice of
And
your
also,
appearance.
this intervener I have received today.
Because
not
even
any
a
intervention.
formal intervention is not there from your side.
Certainly not. I started with that.
I thought that Mr. Kandan is appearing, so you are representing Mr.
I
The
also
matter
thought
has been filed
I also
yesterday
have the same impression that he is appearing
and
from
mentioned today after lunch.
That was the arrangement.
And I was instructed, even I don't have the full paper, just to assist the court, because if my lords permit me to intervene, I'll intervene, otherwise I'll withdraw. It is a question of law which I have raised
That's
for
it, we
kind
take care of
consideration.
it. We take care of it.
And I must say, Miller, there is a constitutional bench judgment on this issue, that even public sector or undertakings of the state government are in dispute, that it will be original jurisdiction of the Supreme Court.
We'll see
That is why I said, my lords may keep it after 2 weeks, permit me to intervene to assist the court if my lords feels it necessary.
We'll see that.
Then only, otherwise my lords may keep it.
No, sir, Annexure 5 may be seen for a minute, page 67.
What do you want to say? जब आपका क्या पॉइंट है बताइए।
पॉइंट्स हम बता देंगे और पेज 67 से पॉइंट बनाएंगे।
अच्छा,
पॉइंट बना रहे हैं 67 से, हम आपका लोकस दिखाने का कोशिश करेंगे। What is the locus of the state of Jharkhand to file a resolution? For that purpose, I am referring to page 67 and answer 5. Because my name appears at 19, Manoj Kumar Singh, son of so and so, adversary.
yes,
जिसको आउस किया गया है ना, his position is at page 21.
हाँ,
इनका नाम है अफरेम जॉर्ज कुजूर, उप निबंधक है सहयोग समिति झारखंड. If he has been ousted, it's my submission before Milos for consideration. This Aframe George Kujur has a right to file a writ petition, not this state of Jharkhand. A state of Jharkhand has just nominated him. And if this is bad, as my friend has argued before my lords, then this Kujur has only the right to file a writ petition. I substantiate this argument with further something more that I want to take before my lords. My first submission is that why I am intervening before my lords, because my position is 19, he is at page 21, 4 members, ऊपर में देखिए मनोनीत सदस्य. All these 4 have been nominated by the state government. Now with reference to this notes, I will take your lordship to section 48 for a minute. इनका जो नॉमिनेशन है ना वो पर से इलीगल था फ्रॉम वेरी इंसेप्शन. Kindly see section 48 for a minute. Nominee of central government or state government on board. It is before my lords. Where the central government or a state government has subscribed to the share capital of a multi-state cooperative society, the central government or the state government, as the case may be, or any person authorized by central government or the state government shall have right to nominate on board such number of persons as its members on the following basis, namely, I am skipping A, B. Straight way kindly come to C. Where the total amount of issued equity share capital held by the central government or the state government is 51% or more of the total issued share capital, 3 members of the board, meaning thereby not more than 3 can be nominated. Maximum is 3 which can be nominated. और किसका होगा? जिसका 51% से ज्यादा शेयर है. It is only the state of Bihar, existing state of Bihar नहीं, state of Bihar, post 15/11/2000, which has its share to what extent? 99.74. A state Jharkhand has 0% of share capital there. 0%. I am talking of successor state of Jharkhand. 0%. वो जो 26% है, 0.26%, it is not belonging to the state of Jharkhand. It belongs to the cooperative societies located in the state of Jharkhand. You have no role at all, not a single penny. Those cooperative societies may come before this one court that yes, my right is infringed, therefore writ petition under Article 226. How the state of Jharkhand can file a writ petition before this one court? And then this comes Article 131, which my friend has just referred to. If at all the state of Jharkhand wants to file a writ petition against the state of Bihar or the central government, then this jurisdiction lies only and only with the Supreme Court, not with this court. I don't want to refer this 131 because it has already been referred, but if my lordship permit me, just have a look to this again for my purpose. Original jurisdiction of the Supreme Court, 131. Mr. Kujur could have come, lords. Yes, he has a right to come. Locus. The state of Jharkhand, no. Original 131. Original jurisdiction of the Supreme Court, subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the government of India and one or more states. ऐसे ही covered है. Because government of India is also there. You are challenging the decision of the government of India. It's a purely lords election dispute, if my lords may take it from my side. Purely election dispute. Just to defer the election, कि कल election होना है, बाद एक writ petition file कर दी. Nothing more. And my lords, it is well settled that in an election dispute, the writ jurisdiction under Article 226 cannot be invoked. So with reference to this Article 131, also this court does not have jurisdiction as far as the prayer is concerned. My friend is going to the root of the matter 15/11/2025 is bad. Do we dispute at all that yes, I have a share No, in the entire writ petition kindly read it. It is the state of Bihar, successor state of Bihar. Uska registration hai. This whole society is owned by state of Bihar. Multi-state means yes, it operates in different states. You don't have the ownership at all. You have no role at all. This is my humble submission, subject to Milo's consideration.
Where is the registration? Just show me the registration once.
Milo's, this is with the writ petition notes.
And where is the judgment on the basis of this registration?
Yes, Annex 1.
That is being not
Read
This
with,
one?
only
This one?
and notes.
read with 2 and 3.
Before that note, in the bill federation case, this is not a new act of.
Let me address. My friend has already addressed. I did not
Please
disturb.
This is that judgment? This
Yes,
is
this is
writ
judgment.
petition number 2, 3.
Yes. And this judgment note, where it says that under section 84, what similar provisions of 1995, section 84 Act, the multi-estate cooperative society will be deemed to be the multi-cooperative society from the date the reorganization takes place. The provision of section 95 is parameter with section 103 of the present Act. Upon reorganization, the existing cooperative society will be deemed to be a multi-estate cooperative society. Therefore, it has been recognized in Annexure 1, which is the registration by which the field of operation has been defined, to be Bihar and Jharkhand. And are they saying that not they have changed their bylaws? Their bylaws says, section note page 46, that one shall be the registrar cooperative society Jharkhand. It is their bylaws. This is
Now,
not
was Annex
bylaws.
1, Milos have seen it, page 24.
Page 46.
Then was Annex 2
साथ
also.
साथ मत हमको कोई
Milos, let me argue the matter, because my friend has argued two things.
Just some.
बीच में डिस्टर्ब करते हैं उसमें दिक्कत होता है थोड़ा सा. Let me argue, then my friend has a right to reply.
बिना ऑर्डर के नहीं उठेंगे.
Yes. Because advocate जनरल है right of
अब
evidence.
समझने दीजिए आपको इतना कॉन्स्टिट्यूशनल पॉइंट आप लोग रेज कर रहे हैं
Not
तो
my-
सोच के ऑर्डर करना.
नहीं ये बेसिकली क्या है ना कि बिना डिस्प्यूट का डिस्प्यूट है, नहीं कहते बना बात में झगड़ा डालो. This is the only thing. ये इलेक्शन डिस्प्यूट को इन्होंने डिस्प्यूट बना दिया कि हमारा शेयर भी इसमें है.
अगर नहीं
25 साल
करेंगे
से तो कुछ नहीं किया.
अगर नहीं करेंगे तो आप क्या करेंगे?
That's right. Now I am coming to the point. ये स्टेट ऑफ बिहार का ओन फुल्ली सोसाइटी है. It operates in different states. That is why it is called multi-state cooperative society. Because some of the societies are located in the state of Jharkhand also. This does not mean that you have a share. You have zero share in this. And that is why section 48(1)(a)(c) I have referred. 48(1)(c). Maximum 3 members can be recommended by the state of Jharkhand. 4 का issue कहाँ से आ गया? आप कहाँ से nominate कर दिए? Per se it was illegal from its very inception. It is void.
48
1C. Forty-eight 1C. ए भी हम नहीं पढ़े क्योंकि ए भी में कवर्ड नहीं हो रहे हैं. वो में है 26%, लेस देन 26%. जिसका 51% से ज्यादा है ना, उस हालत में भी only 3%, 3 members can be nominated.
ठीक है. जिसका 26% से कम है वो एक नॉमिनेट करेगा. कोई ऐसा कोई मैक्सिमम लिमिट है क्या?
हाँ मैक्सिमम है
कितना है?
ना. मेरा कहना है मैक्सिमम 3 हो सकता है नॉमिनेट.
भाई टोटल मैक्सिमम 3 हो
अच्छा
सकता है,
हम
ऐसा कहाँ से बोल?
ABC दोनों पढ़ लेते हैं.
पढ़ लीजिए.
पढ़ लेते हैं. I have a naya definition because I am a lawyer. I have to interpret it.
आप हमको सिर्फ इतना बताइए कि मैक्सिमम कोई फिक्स्ड है क्या? नॉमिनेशन का मैक्सिमम फिक्स्ड है?
My submission is yes. My friend says no. I say
पहले
yes.
दिखा दीजिए कहाँ.
Now let's kindly see section 48 for a minute again. हम वन से पढ़ते हैं. Where the central government or a state government has subscribed, जो हमारे फ्रेंड हमको प्रोन कर रहे हैं ना साइड से कि हो सकता है ओटियोस हो जाएगा पूरा प्रोविजन अगर इनका बात मान लिया जाए. दिस प्रोविजन विल बिकम ओटियोस. 48 हम फिर से पढ़ते हैं. Where the central government or a state government has subscribed to the share capital of the multi-cooperative society, the central government or the state government, as the case may be, or any person authorized by central government or the state government shall have right to nominate on board such number of persons as its members on the following basis, namely, number 1, where the total amount of issued equity share capital held by central government or the state government is less than 26% of the total issued equity share capital 1 member of the board. So this is first. अगर इतना से कम है तो एक ही हो सकता है. हम इसको लेके चलते हैं कि मैक्सिमम एक हो सकता है अगर परसेंटेज इतना है तो. Second, where the total amount of issued equity share capital held by the central government or the state government is 26% or more, but less than 51% of the total issued equity share capital to members of the board. I take it like this, that maximum 2. अगर इस परसेंटेज से अबव है और 21 से कम है तो मैक्सिमम 2 कर सकता है, not more than this. But this is my interpretation subject to Milo's consideration. C, we are covered by C only, क्योंकि हमारा 99% है. Where the total amount of issued equity share capital held by the central government or the state government is 51% or more of the total issued share capital, 3 members of the board. मेरा कहना है कि मैक्सिमम 3 मेंबर्स, अगर 51% से ज्यादा चाहे 80 हो 90 हो व्हाटएवर, मैक्सिमम 3 कैन बी नॉमिनेटेड. और 3 हमारा स्टेट ऑफ बिहार से किया हुआ है. फोर्थ का जरूरत कहाँ है? इट इज बियॉन्ड द परव्यू ऑफ सेक्शन 48.
ये जो टोटल नंबर ऑफ इशूड इक्विटी शेयर कैपिटल है, अगर स्टेट गवर्नमेंट का 51%
या वो
तो हाँ या वो स्टेट गवर्नमेंट नॉमिनेट कर लेगा, और अगर मान लीजिए बाकी जो है 40% सेंट्रल गवर्नमेंट का, तो सेंट्रल गवर्नमेंट कोई नॉमिनेशन नहीं करेगी. यू वांट टू से दैट?
अगर सेंट्रल गवर्नमेंट का भी है,
सेंट्रल गवर्नमेंट का 40% है, आपका 51% है, तो सेंट्रल गवर्नमेंट का नॉमिनेशन 0 हो जाए.
तो अगर उसका रहेगा शेयर तब वजूद करना है.
हाँ,
अगर रहेगा उसका शेयर तब,
हाँ,
शेयर रहेगा तब हो सकता है. मैक्सिमम है 21 है, मैक्सिमम बिल दिया हुआ 21 हो सकता है.
नहीं 21 हो सकता है.
मतलब इसका जो टोटल मेंबर्स हो सकता है 21 से एक्सीड नहीं. हाँ 21 से एक्सीड नहीं कर सकते.
बताइए ना कहाँ.
लेकिन उसमें
समय से मत बताइए.
उसमें हम आर्ग्यू इसलिए नहीं कर रहे हैं ना क्योंकि
नहीं आप उसी पर बहस करना शुरू किए थे.
नहीं 21 पर
हम
नहीं
आपका
गए.
पहला क्वेश्चन ही वही पूछे हैं. हमारा दिमाग तो वही अटका हुआ जब आप बोलते इससे ज्यादा एक्सीड नहीं कर सकते. अगर 3 हो गया, भाई स्टेट गवर्नमेंट का तो हो गया 51% से ऊपर, उनका 3 नॉमिनेशन हो गया. सेंट्रल गवर्नमेंट का अगर 40 ठीक है, स्टेट ऑफ झारखंड को नील कर दीजिए, मान लीजिए 40. अगर सेंट्रल गवर्नमेंट का 40% हो जाएगा तो उसका नॉमिनेशन 0 हो जाएगा. डू यू वांट मी टू गिव दिस इंटरप्रिटेशन टू दिस?
इसका आंसर है प्रोविजो में. 8C का प्रोविजो देख लीजिए.
पढ़िए.
Provided that the number of such nominated persons shall not exceed 1/3 of the total number of members of the board.
लेकिन टोटल नंबर ऑफ वोट कहाँ है?
21 है, बायलॉज में 21
21 है.
7 हो सकता है, 7 हो सकता है, तो 3 कैसे हो सकता है बोल रहे हैं?
अरे 7 हो सकता है इन डिफरेंट सिचुएशन कि आप 7 से ज्यादा नहीं कर सकते हैं. लेकिन यहाँ जो 48(1)(c) है ना, अगर 51% से ज्यादा है जैसा हम है, अगर आपका ये
लगता है कि थोड़ा सा टेबल में डिक्टेशन का आपको देखना समझने का जरूरत
नहीं. हम बहुत कंक्लूड करते हैं 2 मिनट में. हम पॉइंट वाइज खाली करने दीजिए. फर्स्ट पॉइंट है 131. सेकंड पॉइंट है सेक्शन 48(1)(a).
1A.
सेक्शन
48(1)(a) थोड़ी बोल रहे हैं, 48(1)(c) बोल रहे हैं.
48(1)(c) कि 3 से ज्यादा नहीं हो सकता है. प्लस ऐड कर रहे हैं उसमें कि इनका 0% शेयर है, देयरफॉर देयर कैन नॉट बी एनी नॉमिनेशन फ्रॉम स्टेट ऑफ झारखंड. दिस इज सेकंड. थर्ड इज सेक्शन 84 अल्टरनेटिव रेमेडी.
84 क्या है?
84 is alternative remedy of arbitration in the matter of election dispute. And my lords, I am armed with an order passed by my lords in WPC number 5204 of 2003, decided on 16/12/2024. Just my lords may have a look to this. Just para 5 minutes, my lords may have. at internal page 3. Considering the nature of dispute, initially the notices were issued in the writ petition and the respondent so also directed to apprise the Supreme Court as to whether they are ready for mediation. Ultimately, it was informed by respondent so that they are not ready for mediation in the matter. Further, a supplementary affidavit has been filed mentioning that there is dispute between government of Bihar and Jharkhand which is amenable to the original jurisdiction of Honorable Supreme Court of India, hence the present writ petition in one round. And considering this, my lords have said in para 7, considering the nature of the dispute involved in this court is of the view that a dispute cannot be resolved through the writ petition, etc. Very quickly, then one point is there, they have said in the writ petition that we were never issued any notice. Now, I have alleged with my IA, para 17 is the assertion in the writ petition that we have not been issued any notice. And in answer to that, I have just annexed one document. Perhaps my lords have seen this. Page 8 minutes. This is the notice issued to the minutes निबंधक सहयोग समितियां झारखंड राज्य issued by the returning officer बिस्कोमल पटना जिसका इलेक्शन होने वाला है. And after this notice, this is 22/4/2025, and it is by one office to another office. It cannot be said that you have not received, but subject to correction. What my friends will say, because they have not filed any reply. So, this point that no notice was issued is wrong in my humble submission. From so-and-so to so-and-so, बिस्कोमा बिहार झारखंड के पदधारक के निर्वाचन क्रम में सहयोग समिति अध्ययन संबंध में प्रसंग महाशय उपयुक्त विशेष प्रधान पद द्वारा सरकार विभाग सूचना संबंध में आपसे मंतव्य कर उस पर मंतव्य अनुशंसा की मांग की गई. अनुरोध है कि अनुरोधित आशय के आलोक में अपना मंतव्य 1 सप्ताह के भीतर उपलब्ध कराने की कृपा की जाए ताकि समंतव्य प्रतिवेदन सरकार प्राधिकार सरकार मंत्रालय नई नीति को पेश किया जा सके. This notice was given and thereafter this decision has been taken annexure 8, which is reviewed here.
ये नोटिस जो है आपका 22/4/25 को आपने इशू किया है. क्या मोड से दिया है?
22/4/25.
What is the mode of communication?
So that I do not know. I am not the author of this.
So from where do you get this?
Paragraph 17 we have denied that we have not received any letter.
Yes, and in answer to that note, this has been.
दोनों चीज तो नहीं चलेगा ना.
This has been done.
कहाँ से मिला वो नहीं पता. जो दिया है वो ये नहीं बताया कि कब भेजा.
No, notice has been issued. There is memo number 1107/22/4/2025. It is for them. My lords will issue notice. They will answer how this was done. Now, lords, then lords, I take your lordship to bylaws. This is my 6th point. I am taking it from my lords. 27 was referred. Bylaws in my lords annexure. At page 26, note starts. Page 26. It starts from page 26. The actual note starts from 27, and he has referred to clause 27 thereof. Manus may see at page 46.
Bylaws का कौन सा clause?
27 was referred.
क्या बताना चाहते हैं?
46 page running page 46.
क्या बताना?
इससे इन्होंने दिखाया कि हमारा इसमें हमको यहाँ रहना चाहिए. 1 member रजिस्ट्रार कोऑपरेटिव झारखंड shall be the nominee. 27 माइनस 16. Can you see clause 6? 1 shall be the registrar cooperative society Jharkhand or his nominee. This is what was referred to, if I am correct.
Nominee of registrar co.
Yes. So they say that yes, state of Jharkhand has a claim. Now let's kindly turn to just the start of this page 26. Which is the forwarding.
Page 26.
26 जहाँ से शुरू होता है bylaws. Very important point I am taking from bylaws. ऊपर से है टू एग्जीक्यूटिव सब्जेक्ट है सर है बीच में देखिए क्या लिखा. Bylaws number 27 has not been approved as the proposed amendment was not filled properly. I'm yet to file a counter affidavit, but from the documents I'm showing that this is the position.
तो ये जो नॉमिनेशन की बात हो रही है वो एक्ट से चल रहा है ना, ठीक है, वो ऑलमोस्ट ठीक है
I'm
नॉमिनेशन
referring to only because this was referred to by the petitioner. Otherwise, I should
अंडर द
not.
प्रोविजन ऑफ द एक्ट देयर इज अ प्रोविजन फॉर नॉमिनेशन.
नॉमिनेशन है लेकिन स्टेट ऑफ झारखंड का कहीं कुछ नहीं है ना. स्टेट ऑफ झारखंड दिखाते हैं कि बायलॉज में 27 में है और वो कहता है कि अभी तक ये अप्रूव ही नहीं हुआ है.
इनका नॉमिनेशन वाला सेक्शन कौन सा 48
48.
The right flows from section 48 directly. Bylaws में है चाहे नहीं है, इससे कोई फर्क नहीं. Correct?
और 48 में मैक्सिमम 3 कर सकता है. मैक्सिमम 3 हम किए हुए. सो स्टेट ऑफ झारखंड है इग्नोर हो रहे हैं. और 0% है इनका, कोई एक भी परसेंट इसमें है नहीं से. देयरफॉर स्टेट ऑफ झारखंड हैज नथिंग टू डू विद दिस इलेक्शन प्रोसेस एटसेट्रा, एंड देयरफॉर चैलेंजिंग द इलेक्शन डिस्प्यूट इन रिट जुरिडिक्शन मैटर्स इज नॉट मेंटेनेबल. बिकॉज़ दीज आर माय सबमिशंस.
I appear for state of Bihar and I follow the argument advanced by Manoj Tandon and my lords senior advocate my lord the central government as well as the senior advocate my lord Rajiv Kumar Sinha. This case is not maintainable my lord in the light of my lord's article 131 of the Constitution of India my lords. And my lord has passed one order which has been placed before your lordship my lords in the matter of my lord's Nidesalaya, which was my lord has passed that. And in this case, my lord, the most important thing is that I will give reply, my lord, in detail that how this case is not maintainable. My lord may kindly see paragraph 9 of the writ petition which has been filed, my lords, yesterday. Paragraph 9. And it has been argued by my learned friend Manoj Tandon. I am, my lord, showing from their pleadings. Yes, my lord. White paragraph 7 it is said, my lord, they were registered. That is annexure 1. Then in paragraph 9 they have said, my lords, that bylaws of the Biskuman was amended in consonance with provision of Multi-State Cooperative Societies Act 2002, and the amendment was approved by the Government of India, Ministry of Corporation, by virtue of Certificate of Registration of Amendment issued on 2/2/2024. Then, my lords, paragraph 10. In the light of that annexure 2, it is said, my lords, that Rule 27 of the bylaws provides for the constitution of Board of Directors.
They are deriving their right from the Act. You forget about rule.
lords,
You forget about the bylaws. Act is not to be silent.
My lords, the bylaws, amendment of bylaws is also, my lords,
अरे भाई
required.
गलत लिख दिया है. Forget about that.
ये लगाए इन्हीं के प्लीडिंग से, क्योंकि हम तो जवाब दिए नहीं हैं हुजूर.
ठीक है ना, गलती से लगा दिए हैं चाहे जानबूझ के लगा.
नहीं,
दो
नहीं,
चीज हो सकता है, मिसलीड करने के लिए लगा.
नहीं, ये
तो हम सेक्शन 48 के प्रति आंख तो नहीं बंद कर देंगे
हुजूर,
ना.
हम केवल फिर पैराग्राफ 20 पेज 26 को दिखाएंगे. If he is relying on Rule 27 of that bylaws, that in the light of Rule 27 of the bylaws, one person has to be nominated by the registrar, Cooperative Society State of Jharkhand.
That has not been approved. तो उससे तो कोई मतलब ही नहीं.
वो जब अप्रूव ही नहीं हुआ है, ये नॉमिनेशन कर कैसे सकते हैं?
नॉमिनेशन तो ये किसी का भी कर सकते हैं ना, एज पर द सेक्शन 48.
हुजूर, हमारा ये कहना है, मेरा ये कहना है कि if he is taking a point, it's a pleading in the writ application that he has nominated in the light of Rule 27 of the bylaws, my lords.
तो एक प्रोविजन ऑफ लॉ बाइंडिंग हो जाएगा कि एक्ट बाइंडिंग हो जाएगा.
इनका
आप हमको ये बताइए कि उनको अगर अंडर नॉर्मल सर्कमस्टांसेस नॉमिनेशन का पावर सेक्शन 48 में है कि नहीं
है. अब हम इससे आगे आ रहे हैं. पहले तो ये दिखा दिया हुजूर कि ये अपने प्लीडिंग से ये चीज को बता रहे हैं और पेज 26 में बता रहा है कि दैट इज नॉट अप्रूव्ड. नाउ आई एम कमिंग टू माय लॉर्ड्स annexure 7. And my lords, time and again, my lord, it was argued on the point of asset and liabilities, my lords. It's not a case of asset and liabilities. Matter relates to, my lord, cooperative societies, and matter relates to shareholder share capital. My lord, it is very clear from annexure 7. My lord, because I have not given reply, I am my lords, I am arguing on the my lord, basis of the pleading made by the my lords, on the read. My lord, may kindly see annexure 7, page 70. It is very clear from that. I am reading that. It is of 3/4/2025. Then I will read annexure 8. My lords, अधिसूचना 1081 दिनांक 31/1/2025 द्वारा यह स्पष्ट किया गया, बिहार राज्य क्रय विक्रय संघ के कुल चुकता हिस्सा पूंजी में से बिहार का निवेशित हिस्सा पूंजी 99.26% है। इस क्रम में यह स्पष्ट करना है कि संपूर्ण हिस्सा पूंजी बिहार सरकार द्वारा प्रदत्त एवं धारित है तथा शेष 0.74% हिस्सा पूंजी सदस्य सहकारी समितियों मीनिंग देयर बाय मतलब रेस्ट 0.74 लाइज विद माइनॉरिटी कोऑपरेटिव सोसाइटी। अब आगे हजूर लिखा हुआ है झारखंड सरकार का कि कोई हिस्सा पूंजी बिहार राज्य क्रय विक्रय मीन्स मतलब बिस्को मान में निवेशित नहीं है। सो ही इज जीरो। मतलब once he is zero, then my lord, there is no question of application of section 48(1) A, B or C. And my lord, annexure 8 is very clear thereafter. Annexure 8, my lord, has dealt with each and every letter, my lords, then only my lords it has been issued. And he is challenging that letter issued by the government of India, my lords. And my lords, he is challenging the letter of the state of Bihar, and it is my lords only the honorable apex court, my lord, where the my lords original jurisdiction lies. Annexure 8 को एक बार हुजूर के सामने प्लेस करते हैं जिसमें सारा कुछ लिखा हुआ है. He was given the my lords opportunity to comment upon the letter issued by state of Bihar, which my lord had made a query, my lords, to my learned friend that from where this letter has come, dated 22/4/2025. It is mentioned in Annexure 8, my lords.
क्या पढ़ना चाहते हैं?
My lords.
हम लोग पूरा पढ़ चुके हैं।
हाँ।
स्टेटस उस पोर्शन का ये
हाँ, तो इसमें को 7 दिन का समय दिया। 22/4/2025 का लेटर इशू हुआ है। The letter was issued by the government of India.
The letter was issued by the government of India asking you to call for their comments. On the same day, you also issued a letter to the state of Jharkhand, जो भी authority.
The RO has issued the letter to the cooperative, the state of Jharkhand, to give comment upon the letter which has been issued by the state of Bihar. And
Is the returning officer a party before this court?
Matters, they have not made party. Matters, they are party. Respondent number 5. Respondent
Who
number
is
5.
representing respondent number 5?
Matters, because the matter has been filed only on yesterday. We have been given copy to that matters. Immediately, my lord, we have sent the copy. We have to seek instruction. We have to give reply. I am arguing, my lords, only on the basis of the repetition. He has been made party, my lords, and he has acted upon the letter issued by the government of India, and he did not respond.
Since you are state of Bihar,
My lords,
so I just want your comment on these two documents also. Annexure 9 and Annexure 10. Annexure 9.
Annexure 9.
What do you have to say to this?
My lords, this letter, my lords, relates to year 2000, and it relates to, my lords, asset and liabilities. My lords, what will be the share of the successor state of Bihar, and what will be the share of the successor state of Jharkhand?
The share of the successor state of Bihar and successor state of Jharkhand
My lords,
will be carved out from Biscoman only, or
No.
it will be carved out from somebody else.
my lord, it relates with the entire cooperative societies.
No,
My
it
lords,
relates only to Biscoman.
62% और 37% का जो बात है वो हुजूर एसेट एंड लायबिलिटीज, बिकॉज माय लॉर्ड 41 इज वेरी क्लियर.
आप हमको ये बताइए,
बोलिए.
अगर आपको इनका ये जो लेटर है, it is not relating to Biscoman.
My lords, narrative, but my lords, it relates to asset and properties. 41 section 41 से कि अगर आप एसेट अवेल कर रहे हैं तो लायबिलिटी भी अवेल करना होगा. Then what will be the proportionate?
एसेट कौन अवेल कर रहा है?
The places matter which comes under the
प्लेसेस से क्या
success state
मतलब
of
है?
Jharkhand.
जब आप अपना स्टेटस ही अलग समझते हैं और आप बोलते हैं तो कोऑपरेटिव सोसाइटी है
And it's-
और ये जो है बिस्कोमान इज ओनली नाउ स्टेशनड इन बिहार एंड
Yes.
देन इट इज ऑपरेटिंग इन 2 states.
Yes,
यही
ma'am.
आपका कहना
Yes, yes, this is
ठीक
the-
है?
They,
तो हमारा ये कहना है कि
Ma'am.
it is operating in 2 states, then
Ma'am.
under such circumstances, why there will be any letter fixing any liability on the state of Jharkhand?
my lords, ये लेटर 2000 का है.
खत्म हो गया क्या?
नहीं, ये लेटर एसेट
कॉन्स्टिट्यूशन तो है मतलब 1950 का.
ये
Exist कर रहा है
लेटर
कि नहीं?
एसेट एंड लायबिलिटी से रिलेटेड है.
वही हमारा
ये शेयर
कहना
का-
है, अगर आपके बिस्कोमान को का स्टेट का कोई स्टेक ही नहीं है उस पर, स्टेट को उससे कोई लेना देना नहीं है और सारा का सारा बोर्ड का नॉमिनेशन सिर्फ आप ही का है, इनका कोई शेयर होल्डिंग कोई इक्विटी कुछ नहीं है, तो इनका लायबिलिटी कैसे है?
ये तो क्लियर है एनेक्सर 7 से.
नहीं, लायबिलिटी कैसे? आप इस डॉक्यूमेंट से बताइए, आप स्टेट ऑफ बिहार को रिप्रेजेंट कर रहे हैं.
my lords, equity share and my lords, the asset, my lords, like my lords, so many buildings, so many my lords, the bank accounts, so many infrastructure which were my lords, the places which comes under the successor state of Jharkhand, my lords. Please then you say, please you address. My lords, so my humble submission is that I have to give reply on that, and my lord, it is very clear that the state of Jharkhand has got 0% of share. It is evident from Annexure 7. And in light of that, my lords, he has been deprived, my lords. This is my humble submission, my lords.
और किसी को कुछ बोलना है?
And I have to give reply, my lords, because it is filed only on yesterday.
अब बताइए आप लोग. रेस्पोंडेंट? यस, यूनियन ऑफ इंडिया. इंटरिम रिलीफ बनाइए, बताइए कैसे बनेगा.
ये तो हम नहीं बोल सकते.
बताइए.
पिटिशनर बताएगा, हम नहीं बोल
नहीं,
सकते.
आप ही बताइए.
नहीं, हम नहीं बोल सकते.
आपको नहीं लग रहा आपको कुछ ज्यादा ही कर?
नहीं, हमको नहीं लग रहा है, क्योंकि इसमें अभी कंसेप्चुअली हम लोग को लग रहा है कहीं पर हम लोग गड़बड़ा रहे हैं. कंसेप्चुअली हम गड़बड़ा रहे हैं इस बात को लेकर के कि एसेट्स एंड लायबिलिटी वाला पार्ट पिछला 2000 और मैंने 25 साल से ये मैटर पेंडिंग क्यों है, ये हमको अभी इंस्ट्रक्शन नहीं है, इसीलिए अब मेरे दिमाग में कल से चल रहा है.
The
और
core
सेंट्रल गवर्नमेंट हमको कुछ नहीं बता पा.
issue is after formation of the state of Jharkhand, ये बन गया मल्टी स्टेट कोऑपरेटिव सोसाइटी. जब ये मल्टी स्टेट कोऑपरेटिव सोसाइटी बन गया तो दो चीज हो सकता है कि ये एक कोऑपरेटिव सोसाइटी इज स्टेशन्ड एट पटना एंड इज ऑपरेटिंग इन मल्टीपल स्टेट. दूसरा हो सकता है that in this multi-state cooperative society, the state of Jharkhand and state of Bihar, both of them are participating, and they have assets and liabilities and equities or whatever. Then under अगर मान लीजिए
इसमें दो
just
चीजें. Section 66 Reorganization Act का, और that is to be read with 103. Section 66 जो है general provision as to statutory corporations. Corporate constituted under a central act of the state act. It's a body corporate. Section 7 बोल रहा है. Body corporate बोल रहा है. Section 7 of the act बोल रहा है. ठीक है, हमको अपना मेरा जो समझ है
regarding corporation which is given in the schedule.
सेम है.
बिस्कोमान का फुल फॉर्म क्या होता है? It is a
बिहार स्टेट प्रॉपर्टी मार्केटिंग यूनियन लिमिटेड बिहार एंड झारखंड. नाम ही इसका बदल दिया गया 27 पेज 27 में. इनका बायोलॉजी क्लियर बोलता है. एरिया ऑफ ऑपरेशन बिहार एंड झारखंड है. सेक्शन 95 of the earlier 1984 Act is parameter of section 103. If it was to be confined to one state, it could have been done, but it was to be done by the central government by fixing the area of operation or by giving it a new name. Here, the new name has not been given. The name has been given for Bihar and Jharkhand for both. So it continues to be a multi-state cooperative society. Section 103(2) Milords has been read to your lordship. Parameter of section 95, which has been answered not in that Bihar Milk Federation Milord judgment. Yes.
It is parameter 95.
95 of the earlier act. From it will be
इसमें कौन सा
deemed.
पैराग्राफ आप बोल रहे हैं?
इसमें deemed लिखा हुआ. Deemed to be a multi-state cooperative society from the date of the
That
reorganization.
is the effect of 103, my lord.
That is same parameter of 103.
I am not saying so. But
ये
the
act
fact
नया
remains
2002
so far as the
ये नया बिस्कुमान नया
share capital was to be
ये
determined.
नया
with respect
सोसाइटी
to
नहीं
that
बना है
part.
2002 के बाद या 2000 के बाद, ये पुराना सोसाइटी है. Entire history of Lord Biskuman has been referred to in this judgment which I have given to your lordship. After which note the certificate of registration was given to us.
Therefore, I refer to that so far as the reference of this judgment has mentioned in the registration certificate itself.
Order of the Lord the court, Patna High Court has been referred to. And the clear direction of the Lord Patna High Court that the state of Bihar and the state of Jharkhand will not object to the society being a multi-state cooperative society. Paragraph note case 25 of the judgment. So 103.2 note has also been taken care of by the Patna High Court. By a footnote, it is further clarified that the state of Bihar or the state of Jharkhand shall have no locus to object such a registration of the Biskuman under the Multi-State Cooperative Societies Act 2002.
That is their interpretation with respect to the registration.
Registration, therefore it is a multi-state cooperative. There was a provision under 103.2 to restrict its operation or to give it a new nomenclature. That has not been done. That judgment was taken note in Supreme Court also. I'm sorry,
the
no,
issue number A?
Supreme Court was the judgment हम दे देते हैं. I'm sorry. So that judgment of not milk food petition was, but government of Jharkhand immediately gave an order that as all the cooperative societies, milk societies in Jharkhand will be the assets of Jharkhand. That was challenged in that note. The High Court note struck it down that matter will be referred to the central government. They will decide. Till that time, this order goes of the Jharkhand government. That has been modified by the Supreme Court note. Kindly see. This order, which says that the state Jharkhand government's order is correct, that will continue till the central government decides. Meaning thereby that the assets and all notes will be controlled by Jharkhand note, which are there in Jharkhand. And this is the last paragraph notes. Jharkhand's letter, which was struck down, has been restored by Supreme Court.
May raise a dispute before the central government with respect to the properties.
Properties and operationality and other things. Under 41.
41 of the
Bihar organization.
Bihar.
Nobody is disputing the jurisdiction. But in this judgment also, wrote Biskuman judgment of Patna High Court, page 7, would say, it has been referred that these grievance can be raised either before the court or before Jharkhand High Court or Delhi High Court. Page 7. In that case also wrote registrar properties that is order was challenged. Since it is a multi-state, kindly see page 7 notes towards the middle. In view of the above, the petitioner can very well raise the grievance either before this court or before the Jharkhand High Court or before the Delhi High Court.
This was been in connection with territorial jurisdiction. No objection was raised under Article 131.
And what this is in reciprocal note, an order passed by the registrar of that is Bihar. Not registering the multi-state notes cooperative society. The reason the Patna High Court says that it has to be registered under the multi-state cooperative society.
WPC number 2485 of 2025. The appearance stated for the learned advocate general appearing on behalf of the state of Jharkhand to the Registrar Cooperative Society government. Third, Mr. Roy, learned counsel appearing on behalf of state of Bihar. Mr. Manoj Tandon on behalf of intervener, namely
number 6374 of
on behalf of Manoj Kumar Singh who is one of the nominees
of the state of Bihar.
of the state of Bihar through IA number 6374 of 2025. Heard that the ASTI, the Net Council appearing on behalf of the Union of India. Respond number 5 to correct upon. Managing Director Viscoman. और किसको नोटिस जाएगा 4. This writ petition has been filed for the following reason.
Motion has been taken. We'll leave for 1 minute. Coming back.
The learned counsel for the learned advocate general has submitted that Bihar State Cooperative Marketing Union Limited, hereinafter referred to as Viscoman, came into existence in 1958, and at that point of time, the state of Bihar had 99.26 shares in Viscoman, and remaining 0.74 share was held by the members of the cooperative society. We submit that upon Bihar Reorganization Act, Viscoman continued to function in both the state, and area of operation was the present state of Bihar as well as the state of Jharkhand. The learned counsel submits that there was a dispute raised in writ petition number 23268 of 2013 between the Board of Directors of Viscoman versus the Government of India, and ultimately a certificate of registration was issued by the Office of Central Registrar of Cooperative Societies, Government of India, indicating that the Viscoman is now registered as Multi-State Cooperative Society under Section 103 of Multi-State Cooperative Societies Act 2002 and the rules framed thereunder, and the registration number of the society was also given way back in the year 2014, while the certificate of registration dated 1st of August 2014 clearly indicating that the area of operation of the society shall be confined to the state of Bihar and Jharkhand. The learned counsel submits that the bylaws as approved have been placed on record, and he has referred to bylaw number 27 to submit that the Registrar Cooperative Society Jharkhand has a right to nominate a person in the board of Viscoman. The learned counsel further submits that a letter was issued by the Joint Registrar of Cooperative Societies Jharkhand to Viscoman, whereby in terms of clause 27 within bracket Roman 6, name of one of Frame George Huzur, Deputy Registrar Cooperative Societies Jharkhand, was nominated for the purposes of election, and he has also referred to another letter dated 21st of February 2025 to submit that the Cooperative Election Authority observed that under section 48 within bracket 1 within bracket A of Multi-State Cooperative Societies Act 2002, in cases where equity share capital held by the central or the state government is less than 26%, they have a right to nominate one member, and therefore the state Jharkhand government's one nomination is within clause 48 within bracket 1 within bracket A of the aforesaid act. It was also indicated that the Jharkhand has equity share value of approximately 14.63 lakhs as indicated by the notification issued by the government of Bihar dated 31/1/2020. The learned counsel submits that ultimately the list of the nominated members was issued and the name of the person nominated by the petitioner was figuring at serial number 21. He submits that the election was deferred from time to time, and on each date the nomination of the and even on 4th of March 2025, which deferred the election, the nomination from the side of the state of Jharkhand was mentioned, which is apparent from Annexure 6. The learned counsel submits that the state of Bihar issued another letter dated 3/4/2025 by referring to the earlier letter dated 31/1/2025 stating that the equity share of the state of Bihar was 99.26% and the remaining 0.74% was that of the cooperative societies, and therefore the state of Jharkhand had no equity share in Biscoman, and observed that the nomination made by the state of Jharkhand was not in accordance with section 48 within bracket 1 within bracket C of the aforesaid act. The learned counsel submits that thereafter the petitioner was surprised to receive the impugned communication as contained in Annexure 8, wherein the said communication of the state of Bihar dated 3/4/2025 was accepted by observing that White by observing that by letter dated 22/4/2024, the comments of government of Jharkhand were sought for 22/4 नहीं होगा ना ये 25 होगा
नहीं 22/4/2025
2025 22/4/2024 within bracket, apparently the date has been wrongly mentioned as 22/4/2024. It ought to have been 22/4/2025. Bracket close. Mentioning that there was a request to, Biscoman was requested to seek comments from the registrar of the cooperative societies on the Bihar government's notification dated 3rd of April 2025 stating that the government of Jharkhand has no shareholding in Biscoman. And having no response, the stand of the state of Bihar was accepted and an order was passed that in absence of any equity shareholding of state of Bihar or state of Jharkhand, the state of Jharkhand would have no nominee. The Learned Council submits that the communication as mentioned in the impugned order dated dated 5th of May 2025 as contained in Annexure 8 asking for the comments from Registrar Cooperative Society Government of Jharkhand was never served upon the petitioner and consequently no response was given. The Learned Council has submitted that, has also referred to Annexure 9 to submit that on the one hand, the state of Bihar has come up with an idea that the state of Jharkhand would have no equity share capital and therefore there would be no nomination, and on the other hand, a letter was issued way back in December 2000 in relation to Biscoman giving the assets and liabilities of the state of Bihar and state of Jharkhand. दोनों का है ना इसमें?
हाँ। स्टेट ऑफ बिहार का 62.27% and 37.73% for Jharkhand.
कहाँ दिया?
Page 76.
And so far as state of Bihar is concerned, their percentage was mentioned as 62.27%, and so far as state of Bihar is state of Jharkhand is concerned, it was mentioned as 37.73%. The Learned Council has submitted that 99 point 26%, which the state of Bihar claims as equity in Biscoman, was in relation to the status as it stood prior to bifurcation. We have submitted that after bifurcation, once the Biscoman has become multi-state cooperative society, the entire share capital of erstwhile state of Bihar cannot be assigned to state of Bihar. We have submitted that the state of Jharkhand would also have equity in Biscoman, and as on date, the assets and liabilities between state of Bihar and state of Jharkhand in connection with Biscoman has not been done. Correct? पहले कभी इलेक्शन हुआ है नहीं पता, वो इसका कहानी किसी को नहीं पता होगा, जो असली चीज है। पहले भी तो नॉमिनेशन हुआ होगा ना, साइलेंस कोई सोल्यूशन तो नहीं है। During the course of arguments, in spite of repeated queries made to the Learned Council for the parties, and also the learned counsel appearing on behalf of intervener, they are not in a position to respond to the query of this court as to whether any previous election of Viskuman was ever undertaken and whether the nominee of state of Bihar was and whether the nominee of state of Jharkhand was accepted by them or not. Correct? The learned counsel submits that the election is scheduled to be held tomorrow, and the election would be, and if the impugned order is not stayed, the election would be undertaken in absence of the nominee of the state of Jharkhand. We have submitted that the state of Jharkhand would suffer irreparable loss and injury if the impugned order is not stayed. The learned counsel appearing on behalf of the intervener has submitted that essentially the dispute is between the state of Bihar and state of Jharkhand, and therefore the present petition is not maintainable. He has further submitted that under section 48 within bracket C, the present state of Bihar having equity more than 51% would be entitled to 3 nominees, and there would be no further room for any nomination from the side of the state of Jharkhand. He has submitted that the state of Jharkhand has 0 share or equity in Viskuman, and therefore there cannot be any nomination from the side of the state of Jharkhand. The learned counsel has also submitted that so far as Rule 27 of the bylaws is concerned, the same was never approved, as is apparent from Annexure 2. Bylaw number 27 was never approved, as is apparent from Annexure 2 to the writ petition. The learned counsel has also submitted that there is a provision for arbitration under section 84 of Multi-State Cooperative Societies Act 2000. He has also submitted that in his intervention application, he has annexed a copy of the communication. इसमें भी 24 ही लिखा हुआ है, 22nd April 24 ही लिखा हुआ है. A copy of the communication 24 ही लिखा हुआ है.
Annexure 8 में उसको क्लियर कर दिया.
क्या क्लियर कर दिया?
22/4/2025.
Communication dated 22/4/2025 issued to the Cooperative Societies State of Jharkhand, calling for comments on the notification issued by State of Bihar dated 3/4/2025 within a period of 1 week, so that the comment may be forwarded to the Central
Cooperative Election Authority. Government of
Central Election Authority of the Cooperative Society. The learned counsel submits that it is incorrect on the part of this petitioner to say that no communication was received. He submits that the petitioner did not respond, and consequently there was no option but to pass Annexure 8. The learned counsel has submitted that the election is scheduled to be held tomorrow, and no interference is called for in election matter. And neither the participation of the nominee of the petitioner can be allowed, nor the election be stated.
For the state of Jharkhand को locus नहीं है.
He has also submitted that the state of Jharkhand has no locus. The repetition at best could have been filed by a friend George Hudur, who was nominated from the side of the state of Jharkhand. The learned counsel appearing on behalf of the state of Bihar has adopted the arguments advanced on behalf of the state of Bihar. No, sorry, on behalf of the intervener. The learned counsel appearing on behalf of the ASDI has submitted that so far as Annexure 8 is concerned, since no response was received from the state of Jharkhand, the order has been rightly passed. He has also submitted that the present repetition is not maintainable in view of Section 84 of the Aforesaid Act of 2002. He has referred to Section 84 within bracket 2 within bracket C to submit that any dispute arising in connection with election of any officer of a multi-state cooperative society is referable to arbitration and is governed by Arbitration and Conciliation Act 1996. और कुछ बोलना? 131 का उन्होंने बहस नहीं किया है, आपका तो बहस लिखा दिया।
आर्टिकल 131 ठीक।
उनका बहस नहीं है 131 का। He has not argued on that. जबरदस्ती उनके मुंह पे आर्गुमेंट मत डालिए।
हम आर्ग्यू किए थे।
आपका लिखा है नहीं लिखा है क्या 131?
नहीं लिखा है।
अच्छा ठीक है। The learned counsel appearing on behalf of the intervener has also submitted that the present petition is not maintainable and the appropriate remedy would be to file a case before the Honorable Supreme Court under Article 131 of the Constitution of India.
Right. One more thing about unless the bifurcation of the assets is being done between the state of Bihar and the state of Jharkhand, so far as that stage is being determined, Section 48 cannot be invoked at this moment for the purpose of nomination by the state of Jharkhand.
The learned counsel for the Union of India has also submitted that unless the assets and liabilities of the state of Bihar and Jharkhand is finalized with respect to Biscoman, the share capital is in Biscoman is finalized. No nomination of the state of Jharkhand can be entertained in terms of Section 48 of the aforesaid Act of 2000. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that admittedly the erstwhile state of Bihar had 99.26% equity in Biscoman and the remaining was with the cooperative societies. However, after creation of state of Jharkhand, the certificate was issued to Biscoman under Section 103 of Multi-State Cooperative Societies Act 2002 and the rules framed thereunder, and the area of operation of the society was the society has now become multi-state cooperative society and the area of operation is the state of Bihar and state of Jharkhand. This has happened by virtue of the provision of Section 103 of the aforesaid Act, And further, by virtue of the order passed by this court by the Honorable Patna High Court in the petition number 23268 of 2013. It appears from the records of this case that initially one notification was issued by the government of Bihar dated 31/1/2025, indicating that the government of Jharkhand has equity value approximately 14.63 lakhs. And as a follow-up to that, the state of Jharkhand was to nominate one person in terms of section 48(1)(a) of the Procedural Act of 2002. Consequently, the state of
in Annexure 7, it is also mentioned about that notification dated 31.
Yes, आपको क्या लग रहा है छूट जाएगा? नहीं छूटेगा, आप छोड़ने देंगे? It appears that pursuant thereto, the nomination was made by the state of Jharkhand, and the election process was also made by the state of Jharkhand, and 3 nominations were made from the state of Bihar, as admittedly they had more than 51% equity, share equity in Biscoman.
This order was passed by Cooperative Election Authority.
The order was passed by the Cooperative Election Authority as contained in Annexure 4. It further appears that the date of election was deferred from time to time, and as late as on 4th of March 2025, the name of directors, the nomination of the state of Jharkhand was indicated. However, the government of Bihar took a U-turn by the Annexure 7 dated 3/4/2025 and appropriated the entire equity share capital in Biscoman to the extent of 99.26%, which stood as the equity of the state of Bihar prior to bifurcation, and indicated that the state of Jharkhand would have zero equity.
वहीं पे हुजूर सबसे ऊपर में लिखा हुआ है कि it is made clear from the notification dated 31/1/2025.
31/1/25 का notification कहाँ?
It is here. It is mentioned by the Annexure 7 that बिस्कोमान के मलट्स अधिसूचना संख्या 1081 दिनांक 31/1/2025 के द्वारा यह स्पष्ट किया गया है कि बिहार राज्य के सज्जन सच मलट्स में बिहार का निवेशित पूंजी 99.26%।
ये लेटर नहीं है 31/1/25 का लेटर नहीं है रिकॉर्ड पर
नहीं, because mallet we have got no opportunity to respond mallets. Therefore mallets हम ये किस का मेंशन कर रहे हैं?
Mallets correctly not referred to in Annexure 4. But the very same letter of 21st January 25 has been referred to indicate a share of Jharkhand. And the same letter note now says Bihar government is saying that 99% referred to in that letter means entirely successor share of Bihar. No share to Bihar, no share to Jharkhand.
Annexure 4 is issued by mallets.
Subsequently, Annexure 7 was issued by the state of Bihar, indicating that as per letter dated 31/1/2025, the state of Bihar would have equity to the extent of 99.26%, and consequently there would be no equity of the state of Jharkhand, and therefore the nomination of the state of Jharkhand under section 4 was not in accordance with section 48 within bracket 1 within bracket C. However, the nomination of the state of Jharkhand was made by the Cooperative Election Authority by referring to section 48 within bracket 1 within bracket A of the aforesaid Act of 2002. This court finds that as per the writ petition, one letter dated 22/4/2024 was issued and calling for comment from the Registrar Cooperative Society to the letter issued by the state of Bihar on 3/4/2025. During the course of argument, it transpired that the letter number has been wrongly mentioned as 22/4/2024. It ought to have been 22/4/2025. And in the impugned order, it has been mentioned that since no response was received, the nomination of there would be only 17 elected directors and 3 nominated directors of the government of Bihar. And the participation of the nominee of the petitioner, the state of Jharkhand, was excluded. As per the writ petition, the letter dated 22/4/2025 was never served upon the petitioner. However, the intervener has placed the letter dated 22/4/2025, but it is not clear from the letter as to how and in what mode the same was communicated to the state of Bihar. Considering the totality of facts and circumstances of this case, this court is of the view that the dispute is primarily between the equity share in Biscoman between state of Bihar, between the present state of Bihar and the state of Jharkhand.
Successor states.
Yes, successor states of erstwhile state of Bihar. In such circumstances, this court is of the view that at this stage, this court is not satisfied that the present writ petition is not maintainable and the dispute can be raised only before the Honorable Supreme Court under Article 131 of the Constitution of India. However, this is subject to counter affidavit and any objection which may be raised in the counter affidavit by the respective parties. So far as the election which is scheduled to be held tomorrow is concerned, this court is of the view that the election so held will be subject to the final result of this case. And the respondents are directed to file their respective counter affidavits within a period of 1 week completed. आप एक हफ्ता में फाइल कर देंगे यूनियन. This court is of the view that the core issue which is involved in the present cases as
will be in vacation.
Then it was not stay the election. Well, let the final rights be decided and then the election.
नहीं हो जाता
So elections itself don't have been not revised.
Just
Or we may be permitted subject to the result.
Will not permit them, if you
But
not
elections cannot be not set aside once
It will be
elections.
subject to the result.
Elections once
आप
are
मेरा
held.
मेरा एक important कुछ sentence था उसको आप complete नहीं करने दिए.
अच्छा.
कुछ I was indicating something.
within
आप
1
एक
week.
हफ्ता में फाइल करिए ना.
Yes, yes.
उसके लिए कोर्ट तो खुला ही हुआ है.
No, we'll do it, madam.
The
Therefore,
results will not be declared.
Yes. Results क्यों नहीं आए?
Election was the result with more subject to decision means not result will be outcome of the decision. Otherwise, the results also declared.
The results we declared.
Results may not be declared. No?
The final result of the election may not be declared till the next day of hearing.
Yes, please.
सही नहीं है. This court is of the view that the core issue involved in this case is as to whether after bifurcation of the state of Bihar, whether state of Jharkhand would have any equity in Discoman. Once the Discoman acquires the status of multi-state cooperative society by virtue of force of law, and it is nobody's case that state of Jharkhand would have no assets in connection with Discoman. Rather, it has been argued by both the parties that the assets and liabilities in connection with Discoman between the successor state of Bihar and state of Jharkhand is yet to be finalized. यही core issue yet to be
Yes,
apportioned.
this is the core issue.
इसीलिए बोल दिया कि फिर इसको respond
Even
करेंगे.
if I have 1% share, then what I am get to nominate.
अब order upload कैसे होगा?
Well, formal order of allowing IA is.
हाँ, IA is allowed. आप भी अपना counter file कर दीजिए.
date will be fixed.
Her date is certainly fixed.
Results not certain.
Results will not be pronounced till the next
Yes,
day.
yes.
The counter affidavit, the respective counter affidavit should be filed by
Because the notice has also.
एक हफ्ता दिन में. Notice has also to be.
Notices are also to be.
I will issue notice. By the appearing parties by 16. By the appearing parties by 16. Rejoinder if any by 23rd.
16th of June, my lord.
हाँ.
After my.
Yes.
अच्छा चलिए 20 तारीख तक. Rejoinder if any by 29. And issue notice to respondent number
4 and 5.
4 and 5. It is further made clear that the mode of communication of the letter dated 22/4/2025 to the petitioner should certainly be placed on record. Mode of communication through and with proof of service.
My lord sir said on this, it will be subject to the result.
Next date will not.
हाँ बोलिए.
Next date and not.
I've given the date, not given. Post on 9th. 9 तारीख.
Opening. Yes.
नोटिस का कैसे सर्व करेंगे आप नोटिस? दस्ती ले लीजिए.
10 in addition to the
Through
normal
speed
process.
post, dusty in addition, the affidavit regarding service of notice be filed latest by, I just give you a few words. By 25th of June. The notice should accompany a copy of this. आप लोग requisites कब तक फाइल कर देंगे?
कल कर देंगे.
हाँ लेकिन ऑर्डर करेक्शन होने में टाइम.
हम गिरा देंगे, रिक्वेस्ट गिरा देते हैं.
Requisites by 14.
ठीक.
9th June.
9th June. It is made clear, देखिए recorded proceeding है, कोई problem नहीं होना चाहिए, आप certificate issue कर सकते हैं. Election is not stayed, result will not be declared back to the next.
My lord, that will be made subject to the result of this case. Result may be published. Nomination
कोई
is
बात नहीं,
complete.
थोड़ा रुक जाइए. क्या होगा?
Today the nomination is complete.
6 महीना से 3 बार कैंसिल कर चुके हैं, तो दैट्स नॉट सही।
रिपीटेड कैंसिलेशन भी है और ऐसे कोई दौड़ा भागी नहीं हो सकता है किसी चीज को आउटसाइड द स्टेट का कुछ तो स्टेक्स है ना, कुछ तो इक्विटी होगा ना, ऐसे जीरो कैसे हो जाएगा बताइए।
हमारा राइट छीनने के लिए कितने लोग आ गए हैं एक साथ।
25 साल से कुछ कर ही नहीं है, कर रहे हैं तो फॉल्ट है स्टेट ऑफ
एनीथिंग एल्स एक आपका क्या है बताइए। जस्ट क्या है आपका 16 नंबर का कौन सा पास ओवर है
मेरा बैंक
क्या
that bank freezing of bank account instruction
क्या है कहाँ लेटर
There is no such order in 2025. Ask the department division.
मेरा स्टेनोग्राफर लोग दिएगा
page 15
आज ही करना जरूरी है
कल
कल करना चाहिए लोग बहुत परेशान हो जाएंगे।
I let it to what
Since the court, this case has been mentioned and was heard for some time, the counsel for the state was directed to seek instructions as to whether there is any order or letter dated 21/2/2025 as mentioned in annexure 9 to WPC number 1933 of 2025. She has confirmed that there is no such communication. Counsel for the petitioner has submitted that the only communication is as contained in annexure 8 dated 24/4/2025. As the court time is over, the matter is eligible to proceed. दोनों matter?
Then
क्या हुआ मिस्टर?
whatever is contained, your lordship may post
कल ही
it
कर।
tomorrow.
क्या हो रहा है?
Dispossession,
Deed for
deed
delivery of
for
possession has been
delivery of
issued.
possession was issued there.
तो क्वेश्चन ऑफ लॉ क्या है? बिना एडमिट हुए तो नहीं होगा ना?
नहीं वो ठीक है, not very good case, but your lordship there is one point which is directly involved, that it is a case between a same tribal question is there, whether females would have a right or not. Both the courts have allowed the partition, but they have also held that Hindu Succession Act would apply and
हिंदुआइज्ड हो गए होंगे। यही तो लिखा होगा।
they say, but the daughters are not made party. So once the court below allows the partition claim by few sons, then and the appellate court and the trial court allows the partition on the ground that now it would be under Hindu Succession Act, then the daughters were a party.
कल सुनेंगे देखिए
कल-
कल एक तो वो है
हाँ,
उसके बाद आप
I do get you.
कुछ ऑर्डर्स ना साइन में होता है।
ठीक है।
तो डेट फिक्स्ड नहीं हो पाया है ना, बहुत थोड़ा सा अर्जेंट है। देखते हैं कल कर देंगे, हम समझ गए हम उतना
Your
पढ़
lordship may hear whatever I will not insist.
डिसमिस करना हो तो कर लेंगे।
हाँ, absolutely.